Okay, good afternoon, ladies and gentlemen. The Metropolitan Board of Zoning Appeals is now in session for its regularly scheduled meeting of November 6, 2014. I'm Joey Hargis, and I'll be presenting the cases for review in today's public hearing. This time I would ask everyone either to turn off or put on silent or vibrate your cell phone so as not to interrupt today's proceedings. Honestly, if you're sitting anywhere near me, you're just killing your battery because there's no signal down on this end of the room. So we'd appreciate you doing that for us. The procedure today will be to introduce the case record as the Codes Department has it, and we'll do so on the wall here by means of a PowerPoint presentation. I'll present any letters that we've received in support or opposition to a case, as well as any correspondence we've received from other government agencies. At the conclusion of our presentation, or my presentation rather, the applicants will come first to the table here in front of you. I do have 3 seats available to you, along with any persons in support. After the applicant speaks, those parties that are present in opposition to a case will have a turn to speak, so those folks in opposition will come up after the applicant. And then after the opposition has spoken, the applicant will have a period for rebuttal. The board in their rules provides for cases without opposition 10 minutes for applicants to present their case to this board. To the right of where you're sitting up on the ledge there is your clock. That clock will run for testimony. It will be stopped for questions asked by the board and responses to those questions, and then restarted once you get back into testimony. In a case with opposition, those are known as contested cases. The board provides 15 minutes for each side of a case to present their testimony to the board. Now that 15 minutes is not per speaker, it is per side of a case. So if there are multiple opposition folks, when I'll call for opposition here in a little bit, if you see other hands go up besides yours, you guys huddle up before you get up here and divide your time accordingly. And be fair to your neighbor, don't take all of the 15 minutes that's given to that side. If the applicant wishes to have a rebuttal period, which they're entitled to, they would need to save some of their 15 minutes for rebuttal. All section numbers that are referred today come directly from the Metropolitan Zoning Code, which is Title 17 of the Metro Code of Law. It was adopted by the Metro Council and became effective January 1st, 1998, and applies to the entire jurisdiction of Metro government. I'll introduce and make a part of the record the Zoning Code, a copy of which is at my table. I'll dispense from reading any individual sections unless applicants or opposition request that I read those sections. The Zoning Code requires that these proceedings be taped. Therefore, it's imperative anyone wishing to address this board to come forward, have a seat at the table, identify yourself, and make your presentation. The microphone in front of you is just like mine. You notice a little red ring. The mic's hot. There's a button on the right-hand side to turn it on. When you're done speaking, if you'll turn that off, we'd appreciate it. It should be noted that it's found that anyone's presented false or misleading testimony to this board that may have affected this board's decision. Any approval can be revoked at a later date by means of a show cause hearing. The board will go through all cases set for public hearing today, and after each case, the board will then discuss and vote on that case before you. The board is vested with the power to act on these cases as outlined in Section 1740-180 of the Metro Code of Law. The code requires that 4 members of this 7-member board be present to constitute a quorum. Today I have 5 members present. The code also requires that you have 4 affirmative votes to grant your application. You need 4 of these 5 members to approve your case. In the event you fail to receive 4 votes, your case will stay on our agenda for the next 30 days. Any of these 5 are allowed to change their vote. The 2 members who did not participate can review the record and become eligible at the next meeting. If after 30 days no one changes their vote and no one participates and you're still with a tie vote of, let's say, 3-4 or 2 in your favor, your case will be deemed denied by operation of law. The applicant or any aggrieved property owner may request a rehearing within 60 days of today's public hearing. Further, an applicant or aggrieved property owner may appeal this board's decision to Chantry or Circuit Court within the same 60-day period, but once that 60 days has elapsed, this board's decision is final. And no further action may be taken. If you're an applicant and your case is granted here today, it is necessary for you to come and pick up the permit for which you've applied. It should be noted that you have to obtain that permit within 2 years of today's hearing for this board's approval to remain valid. So if you wait 2 years and a day to come get your permit, you get to start over and come back to this board 2 years from now. If you obtain your permit within that 2-year period, this board's approval, you vest in that approval, and you're allowed to proceed on with your case. Mr. Chairman, I submit that all cases were filed in proper order. Applicants were notified by certified mail as required by the zoning code. All affected property owners within 300 feet were notified by first-class mail, and a legal ad was published in the Tennessean as required by the zoning code. I do have a couple of preliminary announcements before we hear from elected officials. Members present, on our agenda, the first page, case 2014-90, Yebberger, the appellant, at 1921 Broadway. That case has been withdrawn by the applicant. So case 90 will not be heard today. That actually was deferred from our last meeting of October the 2nd. So the applicant has withdrawn that case. Additionally, not appearing on this agenda because the withdrawal actually occurred quite early in the process is case 2014-96. Was a case that was listed on Franklin Pike. So if anyone's here for case 96 or received notice from this office, that case will not be heard here today either. So cases 90 and 96 will not be heard. Okay, that's the preliminary announcements I have. The board does allow elected officials to address this board prior to today's public hearing. Their testimony in this is part of the record, so if there are any elected officials who would like to address this board before we get started, raise your hand. Come on up. Come on up, Councilman. How are you? Good. Help yourself there.
Okay, first let me say good afternoon to the members of the board, and my name is I'm Councilman Walter Hunt, and I'm here to assist Ms. Gardner on Healy Avenue to try and install a carport. She called me, and I visited this area to look at the carport, and I looked at the setback, which, believe it or not, there are setbacks on this street. I looked at where she wanted to put it and observed the other houses that had carports. And all the carports, believe it or not, on the other houses on the side of the house. So it does not interfere with any of the setback, anything like that. However, Ms. Gardner's house is sitting in a situation where she can't put the carport on the side of the house. One side is actually too close to the next house. Then they got the big air conditioning unit on the other side of the house. So I looked at it, and after talking to some of the staff here, a 22-foot carport is going to kind of strain and shorten the setback. I realized that. What was looked at when I went out to look at it, the carport was just actually too long. Matter of fact, 22 feet will fit almost a truck in there. You don't need that kind of a carport with 22 feet when most cars are somewhere in the neighborhood about 12 feet. So I asked her, and she agreed that what you need to do is shorten the 22 feet so it won't violate the setback as much, because the fact that after looking at all of the other members of the neighborhood, which I know very well, they have absolutely no problem with the carport. It's a neat little neighborhood. The carport will fit in terms of the character of the neighborhood. It does not interfere with any of the character. So she agreed to do that, and I thought it would be a good idea to go ahead on and do that and make it in line with the character of the neighborhood. So I fully support the carport reduced down to 12, where it does not interfere with the setback. And I think they have a drawing that she had architect or somebody to do the drawing, and they drew it at 22 feet, and also I think 47 feet from the wall of the house to the street. It was 47 feet. So when you take 12 feet out of that, I just don't think it's going to violate the setback that much. So I really recommend approving it, because when I looked at it, the neighbors are happy. It's a nice neighborhood. It's not going to violate the character of the neighborhood. So for that reason, I urge that we support this particular project. And any questions, I'll be happy to answer.
Did you hear from anyone else in the neighborhood? You said that no one has an objection to it the way it's presented.
Yeah, I've talked to some people about it. Mr. Jordan, Butch Jordan, talked to another lady, gentleman, which I cannot recall the name. He has a carport on the side of his house, and he said, yeah, I understand what she's going through, and I think that it would be good if she could do that, get a car under the port.
Well, Councilman Hunt, I know your time is very valuable. We appreciate you serving your constituents, and this is kind of a model way to kind of hopefully resolve something, to actually go talk to the person, look at it, and then come up with what's reasonable and then present it to us. So we really appreciate you getting this down to where it should be for us to decide whether we should approve or not.
Well, I thank you for having the opportunity to be there. I just believe in looking at and see what is actually real rather than trying to guesstimate it. I do better when I can see it myself. I can't talk about anything I don't see. Thank you.
I have one quick question for you,
yes,
sir.
Sir.
When you're talking about the 12 feet, is that in the width of the carport or the depth
No,
or
sir.
the length of it?
That would be the length.
Typically, cars are about 18 feet long.
Wow.
Parking space is about 18 feet, so I don't want anybody to get misunderstood and ask for something that simply won't do what she thinks it might do at 12 feet. So
Wow.
I happen to be an architect and know a little bit about it.
I was asking one of my colleagues, and I was thinking about my own car. It's about 12 feet. I mean, if you got one of them super duper cars, might be 18. But my car is nowhere near 18 feet.
But your constituent, she's fine with 12, and her car is, do you know what kind of car it is?
Yeah, she's got a Buick. What did you tell me it was? LaCrosse.
Okay, yeah, that's a kind of mid-size.
It's a mid-size. It's not that big one. But I'm going to go, I'm like this, since you said that, then I'm going to go put the tape on it. I'm just like that when somebody give me another idea, and I got to see where the medium is and what's going on. I'm looking at my own car, and based on what my colleague, which I trust very, very much, I don't think it's going to be over 12 feet.
We just want to be sure we didn't shortchange. And somebody said, wait a minute, I thought 12 feet was going to be enough, and I can't get the hood of my car under there or something,
Oh, yeah, I don't think that would happen on this one. And the carport, she can leave half the hood out of it. But it is. I'm going to look at that, though. That's a good point, but because that's one, I can say truthfully, that is one area that I did do a little guesstimation on that. I just stepped off my car, and it's about 12.
The car itself may be about that length. The 18 feet I'm referring to is the length of a parking space. So some people don't pull all the way up or pull up, so I'm just...
Oh, okay, I see where you're coming from. Okay. I think this won't be as large as a parking place.
Okay, all right. Thank you.
Mr. Chairman, I just took the moment to Google the specs. The LaCrosse model appears to be 16 and a half feet long. 16 and a half feet.
Okay. Thank you.
Oh, okay.
With that being said, I mean,
What's the request?
what is there? The initial request was 21. You said 12 or 22. You said 12. we now understand
17.
it's 16, but is 17 acceptable?
Yes.
Okay.
You know, I just don't think that you need an absorbent size carport to put a car on a port. You know, I just don't think you need no more than necessary.
Okay.
You know, if you got 2 feet in the front, 1 feet in the back, then I think the carport's too
Sure.
long anyway.
Thank you, Councilman Hunt.
Thank you. Appreciate you.
Are there any other elected officials who wish to address the board before we begin our public hearing? Councilor, you'll wait for your case, okay. Okay. Seeing no other elected officials, the Board of Zoning Appeals has a consent agenda. A board member reviews the record prior to each case, on each case prior to this hearing, and if in their opinion the applicant meets the criteria for the application requested and they feel that testimony in the case would not alter the material facts, they recommend the case to the remainder of the board for approval. I'm going to now call out into the record those cases that have been recommended for the consent agenda by Vice Chairman King, and if you are here in opposition to any of the case numbers I call, please raise your hand. We will pull the case from the consent agenda and hear it in its regular order on the agenda. The first case recommended for the consent agenda is case 2014-92 at the top of page 2. Mr. Smallman, the appellant Magnus Group Incorporated owners at 2306 10th Avenue South, requesting a variance in street setback to construct a new single-family residence. Is there anyone present in opposition to case 92 on 10th Avenue? Okay, last call, seeing none. This case is a consent item. The shallowness of the property necessitates a need for a variance here. This is actually a block face that has already been developed out. All the homes that were constructed prior sit at about 20 to 21 feet. The new regs call for a 40-foot minimum front setback, and this is a replacement of one of those homes back in that same spot. So the shallowness of the lot would necessitate a need for a variance. When you factor in the new front and the rear setback, does not leave them much of a building envelope to work with. So Mr. King recommended that case for consent. Next case recommended for the consent agenda, top of page 3, case 2014-95, Mr. Chad Baker, the appellant Rodney Rosenblum, owner of the property at 5001 Alabama Avenue, requesting a special exception and variance in the required parking spaces in CS. Use the O to renovate and use a 10,000 square foot non-residence building for a kennel. Is there anyone here present opposed or have questions regarding 2014-95 on Alabama Avenue? Okay, Mr. Chairman, seeing none, the applicant's request does meet all the general conditions of the special exception and specific conditions. The applicant did submit a traffic study to Public Works in regards to the required parking. They have agreed with the traffic study and recommended approval for the parking variance in that case. The next case recommended for consent agenda, case 2014-97, Mr. Jim Lickens, the appellant Leonard Amdor, the property owner for the properties located at 1045 through 1101 Archer Street, requesting a variance in the 8th and Archer Street setbacks and special exceptions in the 11th Avenue height and street setbacks, as well as the rear in RM20. Is there any parties present opposed or have questions regarding case 97 on Archer Street? 12th and Orchard. I said 8th, did I? I apologize. I actually have printed 8th Avenue. It is 12th. Thank you. Are there any parties present in opposition or have questions regarding case 97? Okay, Mr. Chairman, seeing none. The Planning Commission, I believe you're in receipt of recommendations from both Planning and Public Works in regards to this case. This is a redevelopment of these properties along the south margin of Archer Street between 12th and 11th Avenues in South Nashville, and they are requesting in some instances to be further from the road than the zoning code requires, and in 2 instances under the special exception along 12th Avenue requesting to be within the setback. And with that, Mr. King recommends consent on case 97. Jerry, was that what the conditions of the planning commission had? Those.
I've got this here.
Do you think? Mr. King, I think these are a part of those as well. Let me double check, make sure the appellant's agreeable to those. I don't know that the appellant has seen these two conditions, so let's circle back to that one here in just a moment, if we could. And then finally, for consent, the last case recommended for the consent agenda, case 2014-100, the middle of page 4, Mr. Kevin Stackhouse, the appellant owner of the property at 414B 33rd Avenue North, requesting variance in side setback in R6 to allow the legal use of the existing single-family townhome. I know I had parties I spoke to prior to the hearing. Is still opposition or questions regarding? Okay. His questions have been answered to his satisfaction. Any other parties present or opposed to case 100 on 33rd Avenue? Last call, seeing none. Members, if you would please take cases 95, 100, and 92 first, and we'll circle back to 97 here in just a moment.
Isn't there a hearing today on the property at Rosebank and Riverside?
Yes, sir. This is
Okay.
The applicant's agreeable to the cases on 97 for 12. Inclusive of the planning commissions. Yes, ma'am. So record reflect, Mr. King, you're amending your consent motion subject to these two conditions placed upon. Reading those for the record, that the building facades provide a minimum of one principal entrance and that the windows will be vertically oriented on a ratio of 2 to 1 or greater. So. And they are agreeable.
Okay.
Well, that's good.
We ready to vote on that?
I'll second.
We have a second. All in favor?
Aye.
Opposed? So moved, Joey.
Mr. Taylor seconds. If you are here for cases 92, 95, 97 with conditions as placed by the Planning Commission, and 100, you have been approved. You're free to go. As those parties depart, we'll call the first case on to consent. First case on our regular agenda today that we will hear will be case 2014-93. Mr. Lewis Raisha, the appellant, if you'll come forward, please, while those parties depart. If you'll give me just a moment to queue up the PowerPoint, and I'll be right back with you. Members, while I bring up the case file for this one, again, the first case that we are discussing today will be case 2014-93. And before we get into today's hearing, are there any parties present in opposition to case 93? Okay, we do have parties present in this case. Okay, let me read first the caption of today's case, and we do actually have a point of clarification that needs to occur before we get into testimony on the case dealing with the point of law that involves issues before this board. Let me read first the caption. Mr. Lewis J. Russ is the appellant owner of the property located at 212 Woodmont Circle, requesting an item D appeal in the R10 district to remove the condition placed upon this board, placed by this Board of Zoning Appeals, not these specific members, but by a prior Board of Zoning Appeals. And the condition placed upon that was for so long as the appellant owns the property and provide for water removal from the basement so as not to flow onto the neighbor's property. This is referred to the board under Section 1740-180 of the Metro Code of Law. The appellant has alleged the board would have jurisdiction under Section 1740-180, item D. And before we begin, I'd like to turn over to the zoning administrator and our legal counsel to discuss with you. So, guys, I'll turn it over to you guys.
This case is a case that was approved in 1979 by the Board of Zoning Appeals. And a condition that was put on the case was that the condition would run with the owner of the property. 2 years earlier, in 1977, and Susan, correct me if I'm wrong, so the Court of Appeals, I believe, issued the case of McClurkin versus the Metropolitan Board of Zoning Appeals. And in that case, McClurkin stated that conditions, zoning type regulations and conditions have to run with the land, that they can't run with the person, that zoning is land use, and it's not contingent upon who happens to own the property at the time. So McClurkin established that point. It established it in 1977. And then this case, the prior case in 1979, came before the board, and the board placed a condition that had it run with, the condition run with the person. So it's what the applicant is requesting here is that that condition running with the person be taken off by this board. And I don't want to put words in the applicant's mouth, but, and I'll let them state their case on it, but they're probably going to suggest that in 1979, when the condition was placed, it shouldn't have been placed, that there was already in place a rule of law that forbid those types of conditions.
Haven't we done the same thing? I think I remember cases where we put a condition with the owner of the property rather than the land itself, and what's the difference?
When you're talking about variances specifically, variances are triggered by topographical conditions. Those are the types of things that a variance can be granted on. And so more specifically, variances should not run with the person, but run with the land, because the variance is being granted based upon some feature of the land. Now, it becomes a bit of a gray area, but we're talking about variances here. Now, the board has jurisdiction over lots of other things, item A, special exceptions, things like that. The law on this is not entirely clear. McClurkin speaks to just this one issue.
But in this case, in item D, is a non-conforming use going to another non-conforming use, and I don't know what the logic was in 1979, but I can't imagine it having anything to do with the topography of the land in terms of being a quadruplex going to a fiveplex in a residential neighborhood that's all single family. It seems like there would be no topographical argument at all that would justify that piece of it. So I guess I don't know, that raises more questions of, it doesn't seem standard to
Right.
that.
Now,
And-
if I could interject there, looking at the 79 appeal, what records we have of the 79 appeal case, it appears to me, it was a straight use variance that this board during that time did grant. Now, it's our board now is legally prohibited from granting such a use variance, but in 79, it appears the record, looking at the sort of the site plan that I show you guys with the caption that's in the record here shows under case number 79333, it says prohibited use. So it appears it was a variance granted under use, which you guys now obviously cannot do.
So there's the answer to that. That's the reason why it came that way.
I've got another question, but I think I'll hold it until we get to maybe ask the other lawyers that question. It may be more applicable to them than it is on.
Yes, so we just have the appellant go ahead and state their case. And
Actually,
I think
Mr.
that
King,
there's, I'm sorry, I think there may be a threshold question here, and the threshold question may be, is this case purely a matter of law? If it's purely a matter of law, and the board does not have the legal authority to deny the applicant's request, then it may be that the board doesn't take it up for full hearing. I'm just suggesting this, or it may be that the board would prefer to have the full hearing on the matter, but keeping in mind that the overriding issue here appears to be an issue of law.
If we don't,
That's the case.
That was the question
Yeah.
I was thinking too, is that
if we don't act on it, then what happens?
they take it to court, right, if they choose.
I would prefer to let the applicant address that question, and the reason being is that the applicant may, for whatever their own reasons, may want to have the hearing on the matter to get an order to that effect.
Yes.
Or the applicant may prefer that it be just approved simply based upon the fact that there appears to be no question of law, that this is solely an issue of law, and there doesn't appear to be a question of law.
I know when we grant a special exception, we look at things like water and light and other issues, sound, about the new property. But if today we had a case, could we use this language and say someone we'll give you some sort of variance, but we can't as long as no water goes on the neighboring property?
I think that is a separate issue from the pure legal issue. Mm-hmm. I don't know if it's relevant here today or not, and that may be something that we need to ask the applicant.
Okay, thank you.
Do we have jurisdiction under this question? Okay, I just want to make sure that if it's a question of law.
It's on the agenda and it's in front of us, so
Well, it's kind of one of those, if we find it to be a question of law, is that an issue?
this is our version of Marbury versus Madison.
This matter came up because I did work with or speak with someone with regard to this case prior to it coming to the BZA, and that was my recommendation, that it needed to come to the BZA in order to remove that condition if the BZA so chose to remove that condition. But that condition could not be removed absent an order of the BZA. So to the extent that that gives the board any comfort, then that was consistent with my reading.
And I'm sorry to be dense. I'm really trying to reconcile what you told us first with my memory of us having given something with a specific owner in mind. And it may have been a special exception, and you said that was different. And I can't remember it exactly, but I was thinking it may have been, a child care, daycare center or something that we said, well, you can do it, but you can't, create it and sell it. And, this is for the applicant at the time, and I can't remember exactly, but I think it may have dealt with a special exception and not a variance. I understand some aspects of variances not making sense to be with an owner. If you have a 10-foot setback that you go to 5 and you build something there and it's just with the owner, that doesn't make a bit of sense. But the special exception in item D, that's where I'm having a little bit of trouble with.
Right. And so the McClurkin case, the court talks extensively about how land use cases are relegated to the land itself, and that whoever's the owner of the property, that is not relevant to the particular use as that use is associated with the land itself. So admittedly, this is a tough and it's a gray area, and I'm not so sure that there's really any law on it. But what I can tell you is under the McClurkin case, the court heavily relied upon the fact that land use regulations, specifically variances, are triggered to topographical features of the land itself. So there could very well be a distinction between variances, special exceptions, item A appeals, and others that the board hears. So there may lay the difference right there. And again, as Mr. Hargis pointed out, evidently this case came as a variance back in 1979, back before the time that use variances were not allowed.
During the Fulton administration.
If you say so.
Our records would indicate it actually even predates Metro. And I hope to answer, the reason it's D on our agenda, D is our sort of catch-all provision for old appeal cases that prior boards dealt with that may have stuck some conditions. We've run into before in Green Hills where it said we'll grant you this parking lot so long as you don't have a ramp cut on that street. Okay, right. And they wanted a ramp cut, so they came back here, and I brought them under D to get. So it's sort of our provision in the code that handles old business that this board has dealt with prior.
Do you have any idea? We said it was brought originally as a variance. Do you have any idea if the word special exception was one that was used in 79, or is that something that's recent?
It's a new.
And because I'd heard you say something about it being a variance, but being a prohibited variance, which seems like maybe that was their language for special exception. And I don't want to get caught too much in the language, but but we're hearing that variance means one thing, but yet what you're saying is it might mean something different that we consider it to be now.
No, I get your question. Back under the prior code, this would have been under COMSO. They called special exceptions conditional uses under that zoning code. That term special exception was not used until 98 with the adoption of this code. They're functionally interchangeable. Some jurisdictions still call them conditional uses. But this one, at least the record we have, it appears to be an outright use variance in 79 that this board now is prohibited from granting.
So does our legal counsel advise us to proceed and hear this case?
Yes, I do.
Okay.
Sorry.
So shall we proceed and turn it over to the...
Yep. Actually, Mr. King, before I turn it over to them, let me finish with my portion of it. But I thought as a prologue to this case, I think it's really important to bring to the board's attention and all other parties present this legal issue that floats sort of in the mix of it. Before we do, though, let me finish my presentation. The subject property, which you'll see here in just a moment on the screen above you. There you go. And in front of you, members, the subject property, which you see here is surrounded in red in the R10 zoning district. These are the structures from an aerial photograph. I am proud to report, members, our aerial photographs are more up to date. We've actually received aerial shot in this year. So February of this year is when this photograph was taken. These are our current aerial photographs that we are, as a city, are attempting to do each February to show the aerial.
Does the city do these, or are these Google Maps?
These are via contract that the city enters into to have done. We do special times like the flood. We had those flown day of or day after when we're dealing with natural disasters. This is a view of the subject property upon my visit to the site. You see my Metro car here in white. And then views of the adjoining properties beside each one. And then as I got out showing photographs, starting in the upper left-hand photograph of the rear structure. Going clockwise, you'll see the rear structure located at the rear of the property, and then the front structure is listed here. The records from the board's case in 79 appear to list that this is the quote on the purpose or the caption from that appeal. It says, to establish the front dwelling and rear dwelling as legal 4-family dwelling and a 1-family dwelling. Total existing dwelling units list as 5 on that. Obviously, it comes here, as I mentioned to you, Mr. Taylor, under item D. Obviously, a 5-unit use in an R10 district is non-conforming, and also under the provisions, sort of our catch-all to deal with prior appeal cases or conditions there too. I'm going to leave this photograph up if I could. With that, I'll, before we begin with the appellant's opposition, I just saw multiple hands out there. Guys, while they're talking, again, you as a group and these folks before us have a group, each have 15 minutes to speak, so please divide your time before coming up. And with that, I'll turn it over to the applicants to identify themselves and make their presentation.
Mr. Chairman, members of the commission, my name is Tom White. I'm here with my law partner, George Dean. We represent the applicant in this case, and to my left is Mr. Louis Risha, who's the owner of the property and has been the owner of the property since 1972. I want to, at the front end, say to the commission, I think this is a straight-up legal question, and I haven't had a chance to discuss this with counsel for the board. I've heard the comments here today, but I agree with what was said by the zoning administrator and also by counsel from the Metro Legal Department. This is a straight-up legal issue. The board does have jurisdiction to hear this. I would ask at the front end that we have 5 minutes for rebuttal. I think we can cover this relatively quickly. But here's the undisputed facts. In 1977, the case was decided of McClurkin versus Metro that was cited by Bill Herbert, the zoning administrator. That case is absolutely clear that as far as a variance itself, and this is a variance case because of questions that have been raised here about variance, special exception, conditional use permit. This was clearly a variance case and a use variance case when it was heard by the board in 1979. The McClurkin case 2 years earlier from our Court of Appeals said that in variance cases, they cannot be restricted to the applicant only, period. The law is that clear. Nobody's going to come here and argue that that is not what the McClurkin case said in 1977. Now, that has nothing to do with conditional use permits, special exceptions. There's other cases. You've got item A cases where this board's called to review an interpretation matter. But as far as a variance itself, McClurkin has been the law since 1977. You cannot restrict a variance to the applicant only. That's what was done in this case when the board heard it in 1979. The second thing that I'll mention to the board is that when the variance was heard by this board in 1979, it was heard as a use variance, which, as you have heard from legal counsel and from the zoning administrator, was clearly allowed to be done at the time. That's why I was down here. My client, Mr. Risha, to my left, acquired this property in 1972. At that time, he converted the property from a 4-unit structure to a 5-unit structure. In 1979, he contacted the local council person, and they came down here to the Board of Zoning Appeals. I obviously was not here. I don't think anybody else in this room was here at the time, but it was granted as a use variance in 1979. It has remained totally unchanged from that point forward. That is, the 5 units, where it sits on the property, all those things have been unchanged since 1979. So my client made the changes in 1972. We're talking about 42 years ago. It came before this board in 1979, or 35 years ago, approved by the board. It's been in that condition since that time. Question might come, why are we here today? We're here today because my client, Mr. Risha, is getting ready to sell the property. And the issue came up when someone checked the record and said this was limited to the applicant only. What was the appropriate thing to do? You have 2 choices. The very simple thing is come before this board and say it can't be restricted to the applicant only and get that lifted. That type of order from this board would allow us to get a clean title and make sure the sale closes out. We could always go to the Chancery Court, Circuit Court, file a lawsuit saying that the board didn't have the authority to restrict it to the applicant only. That would be a totally unnecessary waste of time. I want to be clear, we didn't discuss this matter with Metro Legal in advance. I heard it was commented about today. I don't think you need to speak or have any much dialogue with somebody with legal in advance. It's absolutely clear. McClurkin says on a variance case, you cannot restrict it to an applicant. Nobody credibly can argue that that's not the law and has been since 77. No one can argue that in 1979, this came before this board as a use variance. You had the authority to grant a use variance at the time, and you did. No one can also question the equity of the fact that my client has basically operated this property under the board's authority since 1979 for 35 years under that authority. So I would urge the board to basically take this up as a legal matter. And I'm sorry if some of the people that are here in opposition were unaware of what the law is or that it can or can't be restricted to an applicant. I've not had a chance to speak to any of them. And I'm sorry, because oftentimes you can explain these matters and you don't have people coming down here to these boards once they understand what it is. Nobody doesn't recognize that it's been there as this 5-unit development since they've been out there. It's been there, as I said, since 72. But with that comment, I'd like to ask Mr. Risha, who's sitting to my left, to just confirm the facts that I've given to board about when he acquired it, what he did, and when he did it, if you would. It's Mr. Louis Risha.
I bought the house in 1972. At the time, it was 4 units. I converted it to 5 units. And then a little later, the question came up from came up about it being 5 units. And I went and had talked to the councilman at the time. That was Joe Bandy, and he went down and they had it approved and where it was legal. I'd had no comments from any of the neighbors or anything at the time.
Mr. Chairman, I did want to mention that it's before our time and he's now deceased, but Mr. Joe Bandy, who was well known in the area, was the council person at the time. He's the one that came down here in support of the request. I haven't had a chance to fully review the record. I think it was granted without opposition. Again, I haven't looked at that particular part of the record, but it was that much of a non-event when it was granted in 1979. So rather than take a lot of the board's time, I'll just conclude by saying I think it's unavoidable. It's a legal matter. I think it's unavoidable that it should be approved by the board today, and we're asking for that so that this man does not have to file something at the courthouse to clarify what I think is pretty obvious as a result. But we'll answer any questions as we close, but I would urge the board to grant this today so that my client can move forward. And I apologize that we have not had a chance to discuss these matters with neighbors. I would have done that. I didn't get a call. My client didn't get a call. We would have responded. So I appreciate your courtesies. We'd ask that this be granted under item D. Thank you for your courtesies.
Let me ask you one question, Mr. White. Apparently, a variance was granted, but there are conditions put on that variance. Is that, I guess, maybe I need to ask our counselor.
Yeah, you really have hit on something. There are really kind of two issues involved in this one. One is dealing with so long as the applicant owns the property, and the other is to provide for water removal from the basement as not to flow onto the neighbor's property, which is a condition associated with the land. So you really have two things before you. I would not disagree with anything that council has said for the applicant or that our zoning administrator has said with regard to the McClurkin case. And it may be just a matter of law if the applicant is not seeking removal of that second piece of it that deals with the water removal from the basement of the property. I haven't, as he said, indicated that I haven't had opportunity to talk with him. There was actually, I think, someone else who called me about this particular case in the past, which is why I have some idea about kind of factual basis for the things that are before you today. But so you've got kind of two things. One is really kind of more of a matter of law, which you could make a decision on that, and that would be, and I don't have any thing to suggest otherwise in terms of an interpretation of McClurkin that is different from what has been proposed by the applicant and his attorney and our zoning administrator. However, there still remains that other piece of the condition, and it would really depend on whether or not that's a part of what the request is or whether or not the board would like to see that remain on the as a condition of the use.
And Mr. Chairman, let me address that. We have absolutely no request that condition be removed. It can stay there without any problem. My client has confirmed to me that When that matter came up many, many years ago, he took care of that problem, and actually that water is now pumped into the city system so that we'll avoid that flooding across the face of the property. So we don't have any request that that condition be removed. It can stay there. It's been eliminated. I want the board to know, as a practical matter, it's not that we've got to do anything. It was addressed many years ago, but we don't have any request that that be eliminated. I do want you to know it's been remedied decades ago.
I think of that as I read the wording on it, I would have interpreted that to remove all those, including that condition of the provide for water removal. So I didn't know if we had that right.
That was probably our error in not making that as clear as possible. I really didn't think about it because I thought my client had remedied that not years ago, but decades ago, and he has. But again, that's not something we're asking to be removed as a requirement.
Okay. Anything further to add?
We'll save whatever remaining time for rebuttal if necessary.
You have 8.
He's got a question.
You're off. Okay.
You have 8 minutes and 30 seconds left for rebuttal time.
Thank you.
We'll have the opposition come up now.
Okay. As the appellant step back, if the opposition would come forward, please. I have 3 seats at the table. You're welcome to fill them all, and as well as queue up there behind. As someone does leave the front table, feel free to take their spot when they're done. For the folks in opposition, I understand the clock will run upon your introduction and testimony, but it will stop for any questions or answers there too. And then once you kind of start back into testimony, we'll restart the time. And with that, ladies, the button's right there in front of you to the right, if you'll hit those. And I will turn it over to you all to present your case.
Okay, go ahead and introduce yourselves.
Good afternoon. I'm Betty Kirkland. I reside at 216 Woodmont Circle, which is the property to the right when you looked on the map of Louis Risha's property. I just want to speak briefly to the conditions of the property and what we've experienced in the 13 years of being a neighbor. It was interesting that it was said that it was unchanged since 1979, and it's been in that condition since that time, because that kind of resonated with me. There's not a lot of maintenance. There's not a lot of upkeep. It may well be very similar to how it was 35 years ago. We have dealt with unsanitary conditions around garbage. There's a large graveled area in the front of the lawn that operates as a parking lot. We haven't had good neighborly relations. I would say that if we're looking at the law and saying that this case McClurkin preceded the ruling by 2 years, I wonder if we can't know what the intent of the board was, but at the board at that time might not have granted it at all if they had thought that they couldn't have such a condition with the owner. So I'm not sure that would govern what is decided today. What I do know is in our neighborhood, it is an anomaly. There's a lot of well-kept properties, single-family homes, and this stands out as a dilapidated, different kind of space.
My name is Chris Modisher, and I am also a neighbor. I live around the corner on Clearview Drive. This is an anomaly in the neighborhood. It is a dilapidated property. I am a retired lawyer, but we haven't really looked at this legal issue, and if it is a matter of law, we would appreciate as a neighborhood an opportunity to look at the issue of law. But just off the top of my head, it seems that if the variance was improperly granted, then it reverts to the original condition, and that he's had, the benefit of 35 years of an illegal variance that he has profited from, and that it would revert to what the current zoning is and not what the variance was. I have to say that I have not looked at this legal issue, but if you are going to act on it as a matter of law, we would appreciate having an opportunity to address that issue.
I'm Clara Royer, and I live at 210 Woodmont Circle. I'm on the left. I agree with what was said about the conditions of the property. Did I know a year and a half ago when I bought my property that there were 5 apartments there? Yes. Did I know that it would be so dangerous for the residents of Mr. Risha's apartments to pull out of their driveway that they would drive out of mine? No. Did I know that my view from my kitchen window would be 6 trash containers and parked cars? Yes, I looked out the window. It could turn into 10 trash containers as there are 5 apartments there. This is a neighborhood with home values ranging from just under $500,000 to well over $700,000. I would think you could understand that the neighbors would object to having rental property that is in the condition this property is in.
My name is Jarrett Bell. I reside at 209 Woodmont Circle with my wife and children, and I actually have several other letters that I think some members of the neighborhood didn't have a chance to submit to the board. They asked me to bear on their behalf against the item D request. I understand the legal issue that's been raised here today, and I would submit as Christine Modisher has submitted and others, that if the intent of the board was to grant this variance conditioned upon something, in this case, his ownership of the property, and if that wasn't legally possible to do that, then in that case, that law is null and void, and it never actually had a variance in the first place, and has been operating in effect illegally for those purposes for all of these years. And that's an issue that we should take a look at. And certainly as a neighborhood, we would like to do so with council if necessary, because the reason we would do that is certainly, as some have mentioned, it may be used as have been used in the past as 5 rental units, but there's a reason people take time off during the middle of the day to come in and fight this. And that is because someone has been a very poor neighbor with a dilapidated structure that can only be described as a slum. And I would actually add to what she said, we actually have homes up to about $1.65 million on the street. If you look at Metro tax records, it is completely out of character with the neighborhood. And we're talking about something which, if it were actually used for the intent that it could be used in character, which is a couple of single-family homes on the site, there's still a lot of value to the property. So I think that we're not even materially impacting the current owner's ability to divest the property.
So you're objecting to this owner selling it to someone else and having the continued use? Is that correct?
And being able to continue to use that, yes.
Yes.
As multifamily
you
rental.
said all these things about how you said the property was kept, but if someone else had it, I mean, you're thinking it would be kept the same way?
There's no guarantee that they would keep it in any better shape.
But if we reject this and then the same owner has it, is there anything that's going to change?
Eventually, it's going to be condemned, because I've even heard from people who are tenants there have walked by and complained about, it's kind of funny that you complain about living there. They'd say it's the only thing I can afford. But the sad fact of the matter is they've mentioned unsafe living conditions before.
Can I need to ask our legal counsel a question just to make sure I'm asking them the right question. But it seems to me the only question is the addition of one non-conforming. There were already 4. He was legally allowed to have 4. He added a 5th. There's only 1 that is of the conditions. So the fact that the property can still maintain 4 units is not at question here.
Well, that they raised that question.
But that's what I'm asking. If it was legally conforming for the 4 units, but he added the 5th and came before the board for that 5th, that's my question.
It wasn't legally.
Let me hear from her real quick.
That's a fact question, and so I would have to yield to the staff as to what it actually was in terms of the reason that it came before the BZA to begin with. And if I recall, if this is the same case, and I think it is.
Thank you.
The facts of the case indicated that I thought the gentleman had been cited for not having the proper permits and came in to get a permit for something else. And in the process, it was determined that they did not have the requisite authority to even have the units that were there at the time. Whether those were 4 units or 5, I don't recall. That's a fact question, and the documents should explain that. But
yeah, we have the original letter, and if I read it correctly, it was saying, you're not allowed to have 4 and the one in the back, so you need to come and get this special, permission, whatever we're calling that special permission, variance or a...
Would the current zoning be true?
Conditional variance or a special exception or whatever it is, but I don't think that they I think when they came in originally in 79, according to this letter, that they were legal at all. It wasn't going from 4 to 5. It was like, I got 5 and I want it all to be approved. And they said, it was my understanding, or they approved the 4 and then they later approved the 5th, but it seems like it went through that cycle.
That's what I'm
It
trying to
wasn't.
find out is the history. Was the 4 approved before the 5th came at question?
No.
Take a closer look at that and see what you think of it.
Ms. Jones,
Please
my
tell me.
my reading of it, the letter that went from Mr. Charles Embry, who would be my
Yes.
several predecessors before me, but this is a letter that they wrote saying it appeared that you weren't zoned for any of these. And then that triggered the board's action to approve for 5.
So there wasn't a 4 to 5?
Yeah, essentially that letter that you
None
got
to
in your
5.
packet is a letter saying, we have no record of you having any permits for these 5 units. Come
Thank
for
you.
the BZA.
I did not read that in the letter. Okay, thank you.
But getting back to our agenda, what it says, the request is to remove the condition placed on this in 1979, and that's what we're really here for. That's what we're going to vote on. I mean, I know there's a lot of things being said, but what we're going to vote on is what's in our agenda, whether this condition should be removed or not.
And I will not get into discussion. Maybe I agree, but I think what I read, what I heard Mercedes asking was, what is the impact of our voting on this? Does it, if we were to remove the condition, it clearly could stay 5 units, and the applicant could sell the property and it stay 5 units. If we did not remove the condition, let's say we felt like that, then and the applicant sold the property, is the applicant, they're allowed 4 units? Are they allowed?
But that's just not for us to determine. We're just to determine whether this should be removed or not. Whether they're 4 or 5 units, that's not our call as a board.
Well, I mean, it's certainly my right to ask to know what the answer is. I mean, I'm just curious to know what is the impact of a decision, and I think that is something that, whether or not it's relevant or not, I appreciate you're saying, well, no, it may not be relevant ultimately to our argument, and you're probably right.
I'm just trying to understand the
but I personally am curious to know, well, what really is the implication of what we're deciding here. That's all.
If I understand the facts correct, and is your decision is really, are you going to remove the condition, as it's stated in the application, the condition that was attached by the Board of Zoning Appeals when you heard it? Again, 2 issues here. One is the issue of the ownership. The other is the issue associated with the structure and the land. Those are the only issues before this board. So if you decide not to remove the condition, then it will continue as a permitted structure for 5 units, as is currently the case. If you decide to remove that aspect of it, you are not necessarily removing, unless you so choose, and I wouldn't advise the board to do it, you're not removing anything with relationship to the number of units that are currently existing. That decision was made by the board back in 1979. So they, for whatever reason, decided to allow this use. Their allowance of this use, I do not see as an issue before the board today. I see only the issue of whether or not to essentially remove the note that's associated with it. Now, there may be reasons that the board needs to.
That's what was advertised, that's what was put on the agenda and noticed.
Right, that's what you're deciding today. And you should take into consideration the things that the applicant has said with regard to that, and you should take into consideration the things that the opponents are saying with regard to removing that note, because that's what the application is for. That's what they've applied for. So I think.
I just want to make sure that was clear for our opposition, as to what would happen regardless of one way or the other. I'm sorry.
Right.
I wanted to make sure that there was some clarity here, that what our decision today doesn't take it back to a single-family use.
Exactly, and the reason is because.
That's the issue.
The reason I would say that is because when the board approved it, that was the piece that it ran with the owner or stayed with the owner is a condition of the approval. So you could have the approval without the condition, and that could have been done then too. But they, in addition to approving the use, they also added this condition. So your question is, are you going to remove that condition?
And I guess, and just for information's sake, and it may or may not be relevant here, but let's say that the owner of the property sold the property tomorrow, what is the new property owner allowed to do if the condition stays in place?
If the condition stays in place, he's going to be prohibited from, he won't be able to sell it.
It's not for us to decide. He could sell it,
He
but
could sell
not
it, but it
sell
would be
it.
in violation of the order.
The next person couldn't use all those units. He could still sell
And
it.
again, like council stated, there may be some other remedies out there, legal remedies that they could pursue in court in order to have it removed so that he could have clear title to the land. But really, that's what this case is really about. It's about clear title and whether or not you want to remove that condition or not, one or both.
So the real condition is the wording, so long as the appellant owns the property.
As I hear from from counsel for the appellant, that's my understanding, is that that's the piece that they are interested in removing. Nothing with regard to the water removed from the basement, but only the piece that deals with it being associated with that one particular owner.
Right, okay. Have anything further?
I'm a little bit confused, I guess. If the original permission to have 5 units was granted, conditioned as long as this person owned the property, then I should think that when this person doesn't own the property anymore, that variance goes away, and it would revert back to the original 2-family zoning. And that would be why we would oppose removing the condition, because he can sell the property. It just, the new owner would have different ability to have, would not have the ability to have those 5 units.
That's an opposition where council is combining this.
Well, and I can comment on that, I think. I might agree with that if he were not before this board seeking removal. And I'm going to try not to direct my comments to the opponents, because I know we're to direct to the staff. But in addressing that for the staff, if he were to sell it without removing that and violate that condition, that might be a different story. But
I
depends
know
on,
we're
again,
going
what the
down
cases
this
are.
other road, but let me ask you this while we're going down this road. So it's my understanding that in 1979, he could have 4 units on there, not 5. Is that correct?
No, it's my understanding.
Okay, so it was
that
only 2.
It was only 2.
Okay, so this board, through what we're dealing with today, granted him 3 extra units.
Correct. Well, it's my understanding they were already built when he came to get his permit, and then when he came and got his permit, it was discovered that he wasn't permitted for the 4 or the 5 units. And Joey, I'll yield to you to correct me on any of that, but that was my understanding. So and let me give you somewhat of analogy with regard to, I don't see this as any different than like a note on a plat. You remove a note from a plat, the plat is still approved, but you may remove a condition from it. Similarly, the board may grant a approval, and it may condition that approval on certain things. And should you fail to meet those conditions, then maybe your entire piece goes away. But absent that,
we will ask the applicant when they come back up, but on the November 5th letter from Mr. Dean, on the second paragraph, it says that in 1979, this board granted the application allowing an additional dwelling unit, singular.
okay. Well, like I said, I may stand corrected on the facts of the case, and
but
I will
we'll
yield to
ask them
whatever the
about
record shows.
Sorry, thank you for bearing with us.
And I would just like to reiterate, if they granted it conditioned upon his ownership of the property, and if that wasn't a proper legal action for them to take, then their granting of that variance in the first place is in fact null and void.
Any other opposition comments?
I'm just waiting for you to come up. Sir, you came in late. Do you have anything you want to add? Now is your only chance to speak in opposition.
I was here to speak in opposition.
Come forward.
Well, please come and sit down and turn on the microphone.
Yep.
All righty.
And the reason I bring that, I know you came in late, the opposition only has one period to speak, and that's this time.
Yeah, I appreciate
Yes,
that.
sir, I didn't want you
I
to.
was thinking this was 4 o'clock and it
No
was
problem.
1 o'clock. So I'm here representing the owner of the property across the street from the applicant property, 203 A and B Woodmont Circle. Mrs. Tori Heil, I'm speaking for her. My name is John Missler, and I'm speaking for the property owner across the street, 203 Woodmont Circle, Tori Heil, and she wanted me to express her opposition to the application. It's our position that for whatever reason, they were granted 5 units for as long as the owner owned the property. No matter what the legal nuances are, they're trying to allow the zoning to be conveyed to a new owner who would therefore receive another sweetheart deal for yet some unknown reason. It's not fair to the rest of the neighborhood. These are single-family homes with duplexes allowed in certain conditions. We have a duplex across the street. You just drive down the street of Woodmont Circle and you see mailbox, and then you see this post with 5 mailbox just right there in the middle of a supposedly 1 and 2 family neighborhood. It's incongruous to the broad general plan, I think, of the neighborhood in general. And plus, also, where's the hardship? So, right, you guys have to vote on hardships pretty much. So I don't see where this hardship is, except somebody got a sweetheart deal 30 years ago and they're trying to convey it to a new owner, and there's just no reason. Because if they get 5 units, extra units, then everybody on the block should get 5 units too, is equal treatment under the law. So anyway, thank you.
One more thing, one of the neighbors did point out is that he also did accept back in 1979 that condition with no objections, it appears. So as he mentioned, he's coming in today so he can gain from that.
Thank you. Any further opposition comments? All right, we'll turn it back over to the appellant. You got 8 minutes and 30 seconds left.
Mr. Chairman, I want to clarify exactly what we're here for today, as was mentioned by legal counsel. The only issue today is whether or not we lift the condition that is limited to the applicant only. That's the only issue before the board today. I want to clarify what my client stated and what's consistent with Mr. Dean's letter to the board is that when my client bought the property in 1972, there were 4 units there when he bought it. He expanded it into the 5th unit. That's when he came down here in front of the board. The person that I've mentioned, Mr. Joe Bandy, Mr. Bandy was on this board. Mr. Bandy was on this board. He may have been the chairman of the board for a period of time. But at the time, in 1979, use variances were unquestionably allowed, period. Nobody's disputed that. There's no evidence before you that use variances were not allowed in 1979. There's also no dispute but that the board granted the variance in 1979. And so the issue for the neighbors is Mr. Risha going to continue with 5 units on the property, or is he going to be able to sell it? I've discussed this matter with Mr. Risha. He is selling this to a person that has full intentions to improve and upgrade the property. That's one of the reasons that he has some incentive here. But I want to mention specifically to the board one more time, if the only issue here is do we lift it as to the applicant and the applicant only, I frankly don't see that there's any issue here but a straight-up legal issue on that. And that is the McClurkin case, which nobody disputed, has said in 77 you cannot restrict a variance to the applicant only, period. If that's the case and nobody's saying differently, then the board should grant the request today. The other thing that I'll mention is in listening to the different reasons that were articulated here before the board, I didn't hear anyone say that they weren't aware of the situation when they bought their current residence. Every single person that came up here said, starting with the first one, I've been there for 13 years. Well, my clients had it for 42 years. Everybody was aware. Yes, I knew there'd be garbage cans out there. Yes, I knew multiple post receptacles, et cetera. everybody was aware of what it was at the time. And so you have this attitude of, we've now come in, there's now much more expensive housing in the neighborhood. To call this place a slum is less than a candid observation about what's taking place here. People have come in, and yes, maybe they would like the neighborhood changed to a different scale than what they bought into when they did, but every single one, one person has come here and said, gosh, I was there before 72. I was really offended when he did this. I was there in 79. I was really offended. Every person has said, I've been there a shorter period of time, but my issues are, I really don't like the property. I don't like having multiple units here. But it existed, just in an equitable sense, folks, it existed when they acquired their property. Now, as far as the restriction to applicant only, as I said, unless somebody persuades this board that the McClurkin case is not the law and wasn't the law in 1977, the variance can't be restricted to the applicant only. That's the sole issue before this board. And we can talk about any number of other things, but for people to come and say, well, gosh, if you remove this restriction, then there can't be 5 units there, that's not the case. Mr. Risha can continue with the property, period. But again, I'm asking for the equities of the circumstance are that everyone that has come here before you today was aware of the situation when they acquired their property. And I want to say, equity shouldn't drive the entire decision of the board. I think it's a legal matter. But if McClurkin means what it says, and nobody legally trained has said differently than that, and if it was granted in 1979 as a use variance, which was totally lawful, and it was, and there's no dispute about that, then the simple matter is, should the board eliminate this condition? We urge you to do that. And again, in thinking through the reasons that were articulated to the board, I can't object if somebody wants to say we all want to have $500,000, $1 million houses on our street, but it doesn't change the fact about what the law is here and what's equitable. I think the best thing in part for the residences out there is that if in fact there is a new owner who's willing to invest some additional monies, I think that's a good thing. They seem not to have the highest opinion of a piece of property that allows 5 units. But I'm commenting, there's not many of us that haven't lived in circumstances before where you haven't upgraded yourself. And this is a situation where I think this is a good housing opportunity for people in that area. We'd respectfully ask the board to consider our request, which is to eliminate the condition of applicant and applicant only. That's what the law mandates, and mandates from 77 forward, 2 years before the board made the decision. And again, as far as Mr. Bandy, I don't know if Mr. Bandy was the chairman at the time. He was on this board for many years. So I think he would have known what was being requested here. Anyway, we respectfully ask the board to decide this as a matter of law and move forward. Thank you for your courtesies. We'll answer any questions. My client can answer the fact that his proposal here, although he's owned it for all these years, is that he feels that there's someone that's willing to invest significant money because there is a higher upgrade in the neighborhood that he thinks would justify the improvements. We'll answer any questions. Thank you for your courtesies.
Mr. White, I'll ask you one question. This might be simple in my mind, it is, but I guess my question is, why didn't the appellant go directly to the court if the issue of this board doesn't have the power to place the restriction on the property owner? Why didn't you go directly to the court rather than this board?
Time and money, Mr. Chairman.
Okay.
Time and money, Mr. Chairman. It's a very simple matter. Time and money, Mr. Chairman. I mean, there's nobody that's legally said that we're incorrect about this. Nobody. And if that's the case, it's a relatively simple matter to come before this board and ask you to do what the law requires. And in filing it, Mr. Dean and I do a lot of work in the Circuit and Chancery Court. You're talking about, in my opinion, a minimum, perhaps a 9-month period of time, maybe longer than that. And it's a significant expense. Number one, you got to figure out who you sue in this case. Is it, you include all the neighbors? Are they aggrieved parties? But again, the simple answer is, if we're right about the law, and everybody here who's legally trained has told you that we are, it would be just a total waste of time to go to the courthouse and try to do that. And we shouldn't be obligated to do that. We should come in front of this board. I think that's one of your functions, which is what we've asked for.
Yeah, and I wondered about that too. And remember when we started this, we asked our lawyer, do we have jurisdiction? She said yes. And if she said that we didn't have jurisdiction, I would have said, Mr. White, go to court. But if we can hear this case, that's why we're here.
Okay.
Any other questions? Okay. Anything else to add?
Thank you for your courtesies today.
Thank you, sir.
Mr. Chairman, this closes public hearing on case 2014-93.
I agree with our legal counsel and the zoning administrator that this is a strictly legal case. And one of the things that Mr. White said at the end was, has anyone convinced us that this McCurkin case that's been around for a long time is no longer good law, not applicable to here, or been overturned? And to me, that answer is no.
Well, the only thing about it that raises question with me on to that point is that it happened 2 years after the case was decided, and we've had some fairly controversial things that we've had to deal with that have gone to court, and we're pretty aware of what the court's saying because we want that guidance. And so, yeah, I don't know if they had legal counsel at the zoning hearing of the time, like we do. I don't know that they didn't know what the court said, but if I can only use my experience as an example, we do have legal counsel, and we do know what the court's doing, and at the time they felt like they made the right decision by putting that criteria on it. And so that's what I'm struggling with, is it, asking the question, well, why would they put something on it that no one objected to at the time, thinking that it was not legal? And so, I mean, that is, to some extent, an answer to the question, is that they didn't think it was illegal. They thought it was perfectly fine to do that, and maybe in full knowledge or no knowledge of the court. I don't, like I said, I don't know that I can only assume that they had the same resources that we do and that they had some knowledge of what was going on.
I don't think we can, with all due respect, David, I don't think we can go back and run around in their heads as far as what was before them. I think what's before us is that this is a matter of law, and we've been instructed that this was an inappropriate condition from the get-go. So it really limits, I think, our purview as far as what it is we're considering. And so, with all due respect to the neighbors and all of the other elements, I think there's a very limited perspective as far as what we can consider in this case. And so that, for me, kind of changes the outcome. I have so much respect for all of those elements and the complaints you all have. I'm certainly hoping that the landlord will do something right by this property, but I think we can only consider that very limited piece of information.
I guess the other question I have is, and it goes back to this case and helping me understand this case, is under what conditions, and I asked it earlier, and I think the answer was, I'm asking it again to make sure that I remembered it. What conditions could we put on a case before us that ran with the owner? And I thought that special exception was one that was legit. And if that's, well, and
What are you asking? Can we put it?
No, I'm just saying, and again, please tell me if I'm
Well, I
wrong.
guess what we're saying is, or I'm trying to say, I'm pulling you back, what's before us here is whether to lift this or not.
Well, exactly, but what I'm saying, but the logic of lifting it is that that board didn't have the authority, and we need to correct it.
They did have the authority to put that on in they did.
They put it on there, but the case itself said they didn't.
I mean, we have the authority to do a lot of things, and if it's wrong, Metro will sue us, as they've done before, and then they'll go to court, or somebody else will sue us.
I don't think it's a question of did that board have the authority.
Or were they correct in doing? I mean, you're saying
I think they had the authority to grant the variance to allow 4 or 5, whatever they did. I think the question is, did they have the authority to
make it a condition?
Make it conditional to that one owner. I think that's the issue right here. Right.
No, I understand that. I'm just saying that. Well, I understand that, and I'm just saying that. I'm trying to understand what's the basis. We have one side saying, well, it's just a plain and simple variance, and yet, and therefore that board did not have the authority, or didn't have the legal basis to put that condition on.
But they did have the authority to grant variance.
Absolutely,
It's just the
I'm not
condition
right. I understand. I'm 100% with you.
Okay.
But I'm just saying that condition was put on there for a good reason at a public hearing that was important at the time. And I'm saying that it feels to me much more like a special exception where somebody went.
But we can't talk about that because it didn't exist, and that's not what's in
That's
front
not
of
what
us.
they're asking, yeah.
We're asking whether to lift this or not, and that's it. And it's a legal matter.
If you're, okay. I mean, I understand that. But what I'm saying is, if it's purely based on our belief that the court decision 2 years earlier trumps their decision 2 years later, I'm saying that it needs more discussion because I think that they didn't believe the BZA at the time. In my opinion, I don't have the magic ball, and I don't have the transcript, I don't have anything else. In my opinion, they did it for good reason. And the good reason I can see in my head is somebody bought a quadruplex, they went to add on, they were told they had an illegal quadruplex and they had to right the situation. We see these cases a lot. And somebody says, that really stinks for you, and we're sorry that you did it, but we're going to remedy this, and we're going to say as long as you own it, it's okay, because you shouldn't suffer from an innocent mistake, have you?
I don't remember any of those cases in front of us, because if it's an additional unit, what are you going to do when you sell it? I don't ever remember us saying, hey, we'll give you an additional unit.
When things are made right, and so I'm just saying it. I haven't heard anything other than this was a mistake and it needs to be fixed, and I just don't know that that's our.
It's not necessarily. They didn't say it was a mistake. They just said they're asking us to lift it.
Well, the logic for lifting it was that the court has ruled that it's not legal. That's their only.
But they agreed that their authority to give a 5-unit approval existed and was not illegal. It was conditioning it to the one owner of use instead of to the land use.
I understand that.
And so we're only in consideration of the one owner versus land use, not whether or not the 5 units are legal.
I understand that.
Okay, so our only thing we're in consideration of right now is whether the board was in its legal capacity to put one use owner.
And I'm saying that there very well could have been logic and reason at the time, that the court decision at the time was close enough that it should have been known, and that the board at the time probably felt like they were doing something legal, and I don't see a reason to remove that stipulation that was known and told at the time, and the owner of the property knew at the time that it was there. That's all I'm saying, is that I'm just making an assumption that that board at the time did what they felt like was legal, and I'm willing to support that board's decision. And if there's a legal case that should be decided somewhere else, so that should be decided somewhere else.
Something that happened in 1979 that now is in front of us, that based on this case, it is still good law. I'm not willing to support that decision, and I wouldn't expect someone in 2049 to support something that we did that was wrong. So future Board of Zoning Appeals, if we screw up 35 years from now, fix it.
Let me ask legal advice. Is this board and this condition, this case here, empowered to lift that and change conditions on that? Put a different condition?
We're just.
I did not anticipate this case being quite this difficult. Now, you're asking whether or not this board can put on a different condition for this case? Okay. I've just been informed it was not advertised in that manner. So for purposes of today, the answer then would be no. Again, it's only whether or not you want to lift this condition. That's the only issue before the board.
Mr. Chairman, are you going to make a motion? I mean, I think we've discussed it pretty thoroughly at this point.
You ready to make one? Go ahead.
Well, I would move that I'm going to agree with, based upon the applicant's position, that this is a legal issue as to whether or not the condition of sole ownership or the related to the ownership of the property be lifted that we make a motion that it be lifted.
And I would agree with that, except that I would say that we wouldn't lift the part in there about provide for the water removal.
No, agreed.
This would only be for the.
I would agree.
So that it runs with the land and not with the water.
Right. Any other?
Is that a second?
Was that a second?
I'll second it with that addition, yes.
Okay.
All right. Ask for a vote.
All right. Any other discussion?
No.
I want to be very clear of what we're voting on for the motion. Joey, can you read to us what we're voting on and what's the legal effect of what we're voting on?
I will let me tell you this. I make the best notes I can over here. I will empower the use, since this is being recorded. I will go back and watch this before I enter any order.
But my understanding of
But
what
my
we're
understanding
voting
is
on,
you're asking to,
we are lifting
you are
this
lifting the owner
as
so
it
long as the appellant
applies
owns
to
the
the
property.
number of units. So this particular owner could sell it to
Absolutely.
somebody else, and they could operate 5 units
Yes.
at this address.
Yes.
And so
The motion as
We are overturning the Board of Zoning Appeals from 1979.
The condition.
Not so much
We're
that.
just lifting the
The
condition.
condition. We are overturning condition.
No, you're not overturning anything.
We're lifting the condition.
There you go.
That's it.
You are
From
lifting.
we're just lifting that condition. And so the legal effect is that condition is removed. The part about the water and the neighboring property remains.
Correct. The motion by Ms. Chappell is to remove the so long as the appellant owns the property condition. That's it.
Okay.
And we have a second.
And the chairman added that the condition of the water flow would remain.
Yeah, and I'm just by omission
Okay.
including that.
We're all clear.
Yep.
I think we're bound to. All right. All in favor of the motion, say aye.
Aye.
Opposed?
No.
Okay. This is-
Motion carries on a vote of 4-1 against. Thank you.
Guys, I'm going to see you.
Okay. We miss you.
Mr. Chairman, do you call the next case? Mr. King? We calling the next case, or are we recessing for a moment?
Give us like.
Plow. Plow on. Plow on. Plow on. 3 minutes? Okay.
Yeah, we got one member come read, but we're going to proceed.
Plow on.
Okay, the next case before the board, case 2014-94, Ms. Lori Perry, the appellant. Ms. Perry, if you'll come forward, please, ma'am. Nader Karshinas, the owner of the property located at 2011 Lebanon Pike, requesting special exception and a variance in lot size requirements in the RS-15 district to expand the existing daycare center to upwards to 50 children, referred to the board under section 17-16-170C2 alpha. The appellant has alleged the board would have jurisdiction under section 1740. 180 items B and C. And before we begin, let me pull up. Members, this case comes before you, request Ms. Perry to increase her existing child care facility approved by this board from a Class 1 daycare to a Class 2 daycare. The board, in the prior case, granted a variance in the landscaping conditions for this daycare facility. This is the subject property which you see is surrounded in red. This is located on Lebanon Pike, just east of Quinn Circle, or actually between the Quinn Circles, as you see here. It is in the RS-15 zoning district. And an aerial photograph again from February showing the subject property. Okay. As I said, this is a special exception because of a change of class. The zoning code requires that changes of class come back to this board to seek approval for a new special exception on the matter from going from Class 1 to Class 2. It does not in any way, shape, or form remove the ability for the applicant to continue to do Class 1 daycare. So this is a request to go from Class 2 to 1. The variance request under Section 17-16-170C2 deals with the lot area provisions. And let me read from the code the requirements for lot area. for Class 2 daycares under that section. It states that Class 2 daycares, Class 2A lot size, the minimum lot size shall be 1 acre. The appellant's property has 0.63 acres, a little less than 2/3 of an acre, and the variance she is seeking is for a variance in the acreage of 0.37 acres. This is looking at the subject property upon my visit to the site. I'm standing in her parking area looking toward the structure. Lebanon Pike would be to my back. And then a view along the, this would be the western property line in these photographs. And then views facing in the upper left, east on Lebanon Pike and then west on Lebanon Pike. To orient you, VFW would be kind of at the far end of this photograph. That the Stones River? Mill Creek, thank you, Councilman. I've always, my entire life, juxtaposed those two creeks, but that would be Mill Creek down there at the bottom of that photograph. That is the request that's before you. I believe you've received comments from the Planning Commission. The applicants are present. Are there any parties besides the applicant at the table here present in support for Ms. Perry's request? Okay, see no parties here in opposition to the request. Again, those parties present, you'll have 15 minutes in total to divide amongst yourselves, please, before you come up. With that, I'll turn it over to you, Ms. Perry. Ms. Perry has provided information. Members, you've got in a packet of her neighborhood meeting, which she's held. So with that, I'll turn it over to you, Ms. Perry.
My name is Laurie Perry, owner of Donaldson Early Learning Academy at 2011 Lebanon Pike. And I am here to ask for a variance or special exception because of my lot size. I do not meet Class 2 to have 26 to 50 individuals. People ask, well, before you purchased this property, before you signed contracts, why did you not do research? Why, I've been asked that a couple times, more than once. Well, the fact is I did. I started at Codes. I went there first, and I spoke with not Joey Hargis, but who's Walter Morgan. And when he pulled the property up by the address, he said that I could actually have 75 children at that location. Me not being that familiar, I didn't know if he meant that would be later down the road after I was rezoned to commercial, or he didn't mention any zoning. He just said you could have 75 at this location. He said, but I would, he recommended that you talk to your local council person, which is Phil Claiborne, to make sure that he's going to be in support of you, because otherwise you probably don't have much of a chance. So the second thing I did was contacted Mr. Phil Claiborne by phone. We had a lengthy, probably 30-minute conversation, and I documented almost word for word what he told me to do. He told me the steps that I needed to do to get to where I wanted to be, which would be licensed for 50 children eventually at this location. He told me that the easiest way would be to start out going to the BZA to ask for variance in the lot size. And then after that, I would go to the rezoning, and I was even given the application. Now, I was given this application way back in 2013. It even has the dates here written there that Brandon over in Codes wrote. It even had the deadline and the date of the meeting that I was to go to. They circled that I were to pay $1,400, and I'm sorry, I have a piece of gum on hold. My throat tends to get dry if I talk a lot. But it was, and he had put an X here, preliminary and final SP. He had gone through here and made many notes, pertaining to my property. In other words, from the very beginning, I was led to believe that if I made this investment, it would be well worth it, because I would eventually be able to end up with the 50 children that I needed to survive and keep my doors open and up and running, my business up and running there at that location. Since then, seems as though Phil Claiborne has had a change of heart. And that came about halfway through my construction when another preschool opened down the street from me, which now has 2 locations within a mile of each other. Her zoning is the same as mine, residential. Her lot size is the same, about the same as mine. She was allowed to double her capacity without even having to go to the BZA. But it just happened that around that time, I was working late at the preschool one night, 7, 8-ish. I didn't document the time exactly. I was there working alone, and Phil Claiborne walked in the back door, and he said, this was 6 months after he and I had initially talked. He said that you need to walk out and cut your losses right now. And I said, I'm not sure what you mean. He said, cut your losses. I've decided to not back you anymore. I have documentation where he showed up at my initial neighborhood meeting, where he was in support of my preschool from the beginning, and the first, like I said, initial 6 months. So I'm back here. I have found myself back here. Phil Claiborne, I called codes. I talked to Brandon. Brandon said, let me talk to Mr. Claiborne, and then I'll call you back. When he called me back, he said that Mr. Claiborne had told him that I was not allowed to go to the BZA to be heard on this. And also that if I were able to get signatures within 1,000 feet of my location, then he would rezone me to commercial. Therefore, I would be perfectly fine to have 50 children. So I kind of I jotted it down. I made a note, taped it up. Well, I have to get signatures within 1,000 feet, and then he'll change his mind back to supporting me again. But I had talked to an attorney later who said that that's not true. You can go to the BZA. And so I just thought that this might be my better option. I have prepared you a little folder so you can kind of follow me as I talk. I don't have an attorney. Someone said that 90-something% of people who go to the BZA have an attorney. The reason I don't, mine backed out at the last moment. After I faxed him a copy of Exhibit 1, this is an email that was sent out, and for some reason when I called and I asked Linda Huey about this, she said that it was mailed out prematurely and accidentally sent out. I'm not sure why or what brought that about, but it shows that I have already been disapproved or been recommended for disapproval. And the attorney said, you've already lost. I'm not going to take a case that I can't win. So I'm not an attorney, but I'm going to do my best today. If you'll look at, take a look at Exhibit 2, I know that it says that I'm required an acre, and today I'm here to prove that I don't need I'm using maybe a little bit more than half the lot that I have, which is 0.063 of an acre. If you look at Exhibit 2, this shows pictures of areas that are completely separate and not being used at all for the preschool. Every area you see here, there might be duplicates, but there's a total of, not counting the 2-car garage, that would make 4 areas. Other than the 2-car garage, there are 3 places of land that are not being used and never will be. This is the front of my property. If you look on page 2, you can see this is just to the left of my paved area. The paved area only takes up maybe a little bit more than half of my front yard. The rest of it is just grassy area that's maintained. And that area also goes all the way up to the side, around to the back of my building. Completely not necessary, unused, never will be needed. During my initial construction, I went ahead and constructed the building for 50 children because I knew at some point, or at that time thought, I was going to be rezoned. So my building already complies with 50 children in every way if I were to have gone up and been rezoned. My classrooms are measured. They're ready to go. I have enough square footage. I've already been measured by the Department of Human Services for 50 children. Also, this email mentions landscape buffer. My landscape buffer was approved. I did get my sign-offs, and I did get my UNO and was able to open. I've been open for business since April. So it said something about my landscape did not comply, but it does, and I did get a sign-off on that. And it says something about landscaping from the road. So being it said that, I did go ahead, and in Exhibit 3, you can see where I did put a landscape buffer around that small area to block my center as much as possible from the road.
I don't mean to interrupt you, but you said you didn't have a lawyer here. The way we operate, as you've seen, you have 15 minutes, and basically you've used almost all but 6. So you will get a chance to respond to the rebuttal, but only based on the clock. So that's all the time you have left. So you can use it any way you want.
I'm sorry. Thank you for reminding me.
That will be included in your rebuttal.
Thank you for reminding me. Exhibit 4 shows you the integrity of how well I've tried to keep it look and fit in the neighborhood as much as possible. You can see where every tree that could be left absolutely was, every shrub. We're a very secure center. It shows right here a picture of where I have cameras and keypads to keep it as safe as possible. Exhibit 5 shows how beautiful the center is inside and what it has to offer the neighborhood as far as a place to bring their children. Exhibit 6, these are letters from employees who are very happy with their job, and they're very concerned that they're going to lose employment because my daycare cannot sustain itself. Joey Hargis the other day said, we were having a conversation, and he said, takes what? He's very familiar with childcare because it's what he does. What about 35 just to break even? And I'm like, yeah, that's exactly right. So with 24, it just will not sustain itself. So the neighborhood, teachers, myself, a lot of people stand to suffer as a result of not being able to increase to 50. And I have Exhibit 7 shows a new application that I have filed to have to go to 50 children. I already have 80% of my sign-offs because, like I said, this shows I already comply with 50 children. The only thing that may not is I may have to add 1 toilet. But as far as parking spots, I already have all I need for 50 children. And I just wanted to basically show that I use just a little bit more than half, and I have a very large playground, just more space than I need with 0.63 acres. If I were to purchase more land or have access to more land to make an acre, it would not be used for any reason. It would just sit there as vacant land. And I had no opposition show up at my neighborhood meeting, except for Phil Claiborne. That's Exhibit 8. And then I have some letters, also Exhibit 9, from parents saying how happy they are with my preschool and how they would not want to take their children anyplace else. I just think that my preschool is an asset to the community, and it would be sad to see it just simply closed down. I have put everything in my life. Every month, all the money that I have, I've missed doctor's appointments for 2 years because I can't pay the 20%. I have absolutely invested everything I have. I can't start over. I have no money to start over at another location. I feel like I was misled, blindly led into this. I didn't see this coming 6 months into construction, that he suddenly was going to turn on me and decide to not support me after promising from day one to support me, to get me to where I wanted to be, which was 50 children.
Okay, you've got 2 minutes, 26 seconds left, and there's opposition in the room. We'll hear the opposition, then you'll have 2 minutes, 26 seconds to respond back to whatever they may say.
Okay, do I step down while the opposition comes up?
Members, before she steps away, do you have any questions for her on this front end before we turn it over? Okay.
I do have one question. This acreage thing, you say, when did you first hear about the acreage on this, required acreage, which is what you're appealing now, right?
When I was handed this piece of paper that shows daycare centers in residential zone districts, I never thought I would need this because the way the councilman explained to me from day one that I documented word for word just about I would never have been back to the BZA the second time I was supposed to go to zoning to be rezoned. And he...
I guess I'm confused. You're saying that somebody told you that you could disregard what the requirements are there, or what?
No, no one ever told me I could disregard the requirements. But if I were to have filled out this application for the Metro Nashville Planning Department, I would have gone through zoning. It would have hit Phil Claiborne's desk as he told me first. He was supporting me in the beginning, 6 months into construction, when the other daycare down the street opened her second location within a mile apart. That's when he decided to not support me any longer. That's why I'm back here for the second time.
No, we're not, just don't get off on that. I'm just asking you the requirements for 50 people, 50 students or children is 1 acre lot.
Yes, sir.
When did you first know that?
Pretty much from the beginning.
Okay. That's all.
All right. As the appellant steps back, those parties opposed to the case come forward, please. And again, I have 3 seats up here. You're welcome to occupy them all.
Under our rules of the Board of Zoning Appeals, and Councilman Claiborne knows this, he can speak, his time speaking does not count against the opposition if he chooses that.
All right, thank you. And as always, I want to first thank each of you for the time that you put in to serve on the Board of Zoning Appeal. I know that that's a sacrifice and time that is could be spent otherwise, but you feel a passion for this and you do it. And so on behalf of the council, I want to thank you for your service. My name is Phil Claiborne, and I am the councilman for District 15. I live at 2911 Western Hills Drive. And the last time I think that I was here before you was in April of 2013 when we were dealing with the landscape buffer issue that Ms. Perry had talked about. She had contacted me, I think it was in late March, sometime in the March timeframe of 2013, and said that she had an issue with opening her new daycare center, and that she had an issue with landscaping. So I went over to talk to her, and we looked, and the requirement calls for vegetation. The character of her property is such that the driveway is within a couple of feet of the abutting property line. And it just really is not feasible that there could be a landscape buffer there. So I told her, I said, you can go to the Board of Zoning Appeal and you can apply for a variance for a different kind of buffer. You could do a privacy fence perhaps. And so that was the first conversation that I had with Ms. Perry. And as we began to work through that landscape process, I went to the site to look, and she was telling me about how excited she was to come into the community, that she had grew up in the community and was kind of coming back home with a business here, and that her plans were to open, to begin with 25 people, and then to gradually move up and increase her numbers over a period of time to go to 50. And at the time, I told her that I had a concern that she would be able to do that. And she questioned why, and I said, I need to do some research before I need to get back to you. So that's when I gave her the paper that she was talking about in that late March or early April timeframe. And at the time, I told her, in order to move to a Class 2 facility, 26 to 50 individuals, you have to have a 1 acre lot. And you do not have a 1 acre lot, so you cannot meet the lot size. You also have to have a driveway that has access to a collector street. You do not have a driveway that connects to a collector street. You abut directly onto Lebanon Road, which is a U.S. highway. And you also are located too close to an existing daycare facility. The facility that she mentioned in her comments has been on Lebanon Road for I don't know how long. It existed before the current regulations even came about. And so that daycare is grandfathered in as an existing daycare with the number of people that it had originally. So when it changed owners, that grandfathering condition went with the property. So she is within the regulation calls for to be 1,000 feet from an existing daycare facility. She's within just a little less than 300 feet.
Mr. Councilman, can I stop you just for a moment?
Yes.
Because I want to be sure the board understands clarity, and respectfully, let me disagree with you on that.
Okay.
The spacing requirement is 1,000 feet, but it's per block face. So when the code actually says where daycare homes shall not locate on the same block or block face, the 1,000-foot space is per block face. So once that intersecting street comes in, that 1,000 feet starts over.
Okay.
So she's not too close under the code for between child care facilities.
So what is the phrase including any public right-of-way? How does that impact that statement?
This says where the block face is over 1,000 feet. Say regardless of classification, no daycare or daycare home shall locate on the same street, block face, or opposing block face. So in her instance, that intersecting street here at Dunn Circle, that 1,000 feet, or Quinn Circle, that 1,000 feet stops.
Are you reading paragraph 5?
Yes, sir.
And the last line down there says what?
Yeah, it says where a block face is over 1,000 feet, no daycare shall be located within 1,000 feet of another daycare facility measured in direct line. But the preceding sentence says within the block face. That block face ends from Quinn to Quinn.
Okay.
Yeah, so I just didn't want the record to be muddy that she was somehow out of compliance.
But she is in the middle of two daycare facilities within a mile of each other. The existing one that is within 300 feet is a mile from another daycare facility further up Lebanon Road, close to Briley Parkway. So 2 of these requirements she could not meet. So at the time, I told her about the distance, being ignorant of Joey's explanation there. So she did know from the beginning that, and so she asked, well, I have to do more. So how would I do that? And so at that point in time, I explained to her some options that were at least options, that she could go to the BZA and the BZA might give her consideration. I said, there is an option that you could possibly rezone the property, but I would not support in that because there is no commercial zoning in this area. This is a residential area, and zoning this to any kind of commercial basis would be a spot zoning, and doing an SP would only be circumventing the rules, so I would not be supportive of that. So we moved along with the variance for the landscape buffer, and she came back then at a later time and asked me to consider rezoning the property to an SP. And I told her I would not do that, which is consistent with a previous decision that I had made. The lady who owns the daycare center at the corner of Cottage Lane and Lebanon Road had earlier approached me basically about the same issue. wanting to increase some size, wanting to rezone property. And I told her that I would not consider doing that because of the residential nature of the neighborhood, and the only way that we could do that would either be to zone it commercial or to zone it SP, and that I thought there would be significant resistance from the neighborhood, and I just would not be supportive of that. So that owner listened and moved on with another plan. So I've been consistent in dealing with these issues in the same strip during the period of time here. I understand the applicant's desire to add more to her capacity and the need that she has, but she has been told by me and by individuals within the codes department that she could not meet the acreage requirement. So it is an issue of hearing what you want to hear or not hearing what you don't want to hear.
So, Councilman Claiborne, simply put, why do you object to her getting this?
Because she can't meet the requirements.
Okay.
She cannot meet the acreage requirements, and she does not have the kind of access that the rules call onto a collector street. A couple of weeks ago, I took the time one night to go and to go to the 6 most immediate contiguous houses. The house next door to her was vacant at the time. It's being remodeled by a new buyer. They were not present. The house behind her is vacant now. The lady that had been living there is now deceased. The other 3 properties in that immediate area, as I talked to those individuals and explained, they want to know, why is this sign? Why is she having to do this? And I explained to them that she's trying to get a permission to do something that the rules don't allow her to do. And all of them were in agreement that, the daycare is not that intrusive, but if she can't meet the rules, then she shouldn't be allowed to do what somebody else can't do. You should have at least one letter from one of the other neighbors on the other side, I think, that has been submitted earlier in their opposition to it. So basically, in a nutshell, as you say, I'm encouraging and deny the request to basically ignore the code and give her a special exception to do what other people are not allowed to do.
Yes, and I understand what you say, Councilman Claiborne. I just have one more question because that's why we're here at the BZA. People come here every month that basically the code says this, but I want to do this.
Right.
And we hear them out. So under that, and you've been here for circumstances where you've been in favor of someone that the code said this, and you're saying that. Why under this circumstance is that not applicable?
Because I've told her from the very beginning that she couldn't meet the requirements and that I would not support rezoning the property in some way to help her go around the requirements.
Okay. Thank you.
Okay. We'll start the time now for the other opposition. Put your name, please.
Hello, my name is Elias Marrero. I own the property directly to the right of the property in question. First of all, I want to say is I'm a businessman and have had businesses in Metro before. And one of the first things you do when you're going to open a business is you call Metro and ask, what is the procedure to get a business license? The first thing that they tell you is you have to go through zoning. Zoning explains to you the requirements that are necessary. I couldn't see myself investing thousands of dollars in a property which I could not physically see was presently meeting the requirements of what I wanted to do. It would seem only natural that you would do due diligence before you invest money and know that you could put 50 kids in there, number one. Number two, I want to talk about the size requirement of the lot. I imagine that the size requirement is not just based on the size required to run a business, but in a buffer zone, to create a buffer zone between the actual business that you have and the adjacent residential properties. I bought this house, and the house is 10 foot from the my bedrooms are 10 foot from the property line of this daycare. It was built back in 1962, beautiful property, large oak trees, and that was a residence then, and I don't think they ever thought there was going to be a daycare there when they built it. It will affect the quality of my life in that property. Well, you can say there's 25 kids now. What would 50 kids mean? Well, it would mean twice the amount of children. When you go have a cup of coffee out in the morning on your patio, you're going to hear twice as much. When you're trying to sleep at 7:30 in the morning, you're going to have twice as many people pulling into the drive, which is right adjacent to my property, to drop off children. The next factor is traffic flow. Lebanon Pike has become a major thoroughfare of traffic back and forth from Nashville. A lot of people don't want to use the interstates, and they travel Lebanon Pike. You get out there on 8 o'clock in the morning or 3 o'clock in the afternoon on Quinn Circle, trying to make not a left turn, but a right turn onto Lebanon Pike, and you can be there 5 minutes waiting for a chance to get on there. There is no middle zone or median, I guess they call it, in between the 4 lanes where people can pull off to pull into the center. So now you've got 25 more cars coming in and coming out in the middle of busy rush traffic. So that's my opposition, basically. Sound enjoyment of my life, and the fact that it's not zoned for that. So I don't think I should be subject to the consequences that will occur by granting a variance.
Thank you. Do you have anything to add?
My name is Phyllis Craighead. I'm the owner of the 2 properties that everyone else has been speaking of. My original property is on the corner of Cottage Lane and Lebanon Road. And in 1987, I sought a conditional use permit for that property and was granted that as a daycare property. And it has operated as a daycare property since that point in time. A couple of years ago, or it's been about 3 years ago or so now, I contacted Walter Morgan at Codes and I also, about increasing, because my property there is just right at 1 acre. As Ms. Perry says, there's all kind of land, let's use it. But they said no. But he says, you can call your councilman. So I called Councilman Claiborne and said, this is what I would like to do, and would you support that? And he said no. This is my rationale. I would suggest, and I asked about changing to a different zoning, and he would not support that. So I decided what I needed to do was look elsewhere. Knowing what it takes to be successful with a daycare operation, I looked for a property that I could have at least close to 50. I found that and purchased that property back in 2012. It was a, whatever you call it, one of those that's supposed to be a quick claim, but those are the slowest things in the world. It took about 8 months to go through. So it was towards the end of 2012, October, I think, when it closed, but I started that process in early 2012. We opened the doors at the new location, which is just 2 houses in between mine and Miss Perry's. In January, coming this January, we will have been open for 2 years. So we have been there quite some time. Papa John's Pizza still delivers to a place that they call Nana's Daycare. So there's been daycares there long, long time ago. I wish Nana was there to pay for the pizzas, but she's long gone since then. But it does take an appropriate number to survive. But Miss Perry has owned daycare properties before, is my understanding. So she knew what was needed in order to meet the needs financially. As I did initially, I knew that Nana's only had 21 children. And I thought, I can't survive with 21 kids. But when I talked to Codes, I found, no, it's actually the building size. It has been approved for 49 children at my second location. Well, that's why I was able to double my capacity, because it was already in place for me to have 49 children. So I went and found a property with the intent to meet what was already in place, so I would not have to look for something that's outside the ordinances and regulations. I know I was supposed to receive a notice of this hearing. I never did. I just saw the sign on the property and I called Walter Morgan and said, "What's up? What are they doing down there?" And that's how I learned about it. I never got her initial hearing. I was shocked, and my state program evaluator from DHS was shocked to even know that she was going in down there, just for the very reasons that Councilman Claiborne was saying about the proximity to an existing daycare. I was shocked that somebody was basically opening in my back door. But more power to her, she got that. But I believe that she needs to operate with what guidelines she was given to start with. One other thing is that public schools are providing more services for preschool programs. And I'm just afraid what that will do with the market to privately owned daycare programs.
Okay, thank you. Any other opposition want to speak? Okay, we'll have the appellant come back, and you've got 2 minutes and 26 seconds for rebuttal time.
Idea when I looked at my preschool that her property was for sale still. She didn't open until 6 months into my construction after it had already started.
Ms. Perry, I don't want to interrupt you, but you only have a little bit of time, so I think we should focus on the reasons for the requested
He says that I'm not on a
exception.
collector street. Everyone else at Code says it is a collector street, including Joey Hargis told me, and also Walter Morgan said it was a collector street. He says it's not. He told me right from the very beginning that he would support me. When he changed his mind is when this person opened their second daycare. She's trying to dominate the whole area. She has 2 preschools within a mile apart. I was 6 months into my construction the day she opened, before she opened. And he admitted that he went to my neighbors and talked to them and tried to talk them out of supporting me. I've never had opposition.
Ms. Perry, let me stop you one more time. Because what we hear when people come before us, what is helpful to the board, I believe, is when you have talked to the neighbors yourself and made an effort to work things out in a collaborative manner.
Mm-hmm.
And so I understand and it's very difficult. I understand when neighbors come and speak in opposition to something that you want to do. But I wonder if you may want to consider having some time to have some additional discussion with your neighbors to see if there are ways that maybe you can address some of the concerns.
There are no concerns. I've never met these people. They haven't even moved in next door. They just bought the property, so I don't know them. I haven't had an opportunity to meet them. I have no opposition from my neighbors. I didn't last time I went to the BZA. I don't this time.
Thank you.
I've talked to all my neighbors.
I'd like to say something. I'm Barney Fornera. I'm a friend of Lori Perry. Also, there's an MTA, a transit authority bus that stops right in front of her driveway. As far as for traffic problems and what we heard earlier from the gentleman that was sitting right here, it's just, it's just not really going to be a big issue. And there's not 25 cars there at the same time. There's maybe 2 to 3
A preschool
at different times.
Yeah, he's right. A preschool that's licensed for 50 does not mean there's 50 cars there, because if you have 50 children, you're going to have between 10 and 15 absences every single day. You also have your parents who have multiple children. I have parents that have 3 children for one parent, several that have 2 children for one parent. That does not mean that there will be 50 cars, probably half that. So there won't be a disturbance there. I don't disturb any neighbor. You won't find any neighbor that borders my property that says they've ever had noise, traffic, or anything else disturb them in any way. There shouldn't be a traffic issue at all. There wouldn't be 50 cars, probably half or less than that each day with 50 children.
How long have you been open there?
Since April of 2014.
With how many?
They allowed me to open, like he told me initially, 24 is what I initially opened up with, and it will not support itself. I will lose everything, while this owner has 2 preschools within a mile apart of each other.
that's really beside the point.
Okay.
Question is, like my original question was, you were aware of the minimum lot size for 50 patrons? When?
I talked to Claiborne before I signed a contract on the property. He told me that I would go to zoning after going to the BZA. He would be in support of rezoning me. He's not saying that today. Otherwise, I would not have invested my entire life and everything I have into that property. Because if I lose that property, and I will at 24, I have lost everything. I will be homeless. I have 2 seniors that I haven't been able to order class rings or caps and gowns for this year.
Ms. Perry, and let me just say, I saw the photographs of your lot and the work you've done with the structure. It's lovely. All your teachers are happy there. You clearly have some happy families there. And I don't speak for my colleagues, but I'm not swayed by what the other business owner has to say. I am concerned about what who I understood to be the owner of the property next door had to say. So I will ask you again, are there some things that you could discuss with this person and maybe try to reach some agreement about what the concerns are?
Let me add on to what she is saying. What she is saying to you is, and do you understand what Mr. Hargis said at the beginning of this hearing? You need 4 votes to get this, and you only have 4 people up here. Normally we have 7. So if you don't get all 4 of us, you don't get it. Gets either deferred or denied, depending on how we vote.
We actually would re-advertise the case.
Re-advertise it. Okay. So what she is saying is, do you want to basically have some additional time to defer this case, meet with your neighbors, meet with Councilman Claiborne, come up with something, and then come back to us?
I would be happy to, and I would be happy to talk to them. That was the purpose of the neighborhood meeting. They had an opportunity to come over. I would have been happy to answer any questions.
I will say this about doing this. You all are this far apart, and if we defer this and you're just still kind of talking at each other, it's not going to be any different when you come back.
If they have any concerns, I'm more than happy to answer them right now. Or if you defer, I'm not sure what deferring even means.
What deferring means is that you would be at another hearing first on the agenda, depending upon how we do it, but we will work to make it first on the agenda. Maybe
we're not voting today and we're pushing it off to a future meeting so you can go and hopefully have some middle ground with the people that are in opposition.
Would you rather do that or me?
It's not up to me, it's up to you.
It's completely up to you. What you're having a third person on this panel tell you now, and you need 4 votes and 3 of them are going to tell you now, it is absolutely in your best interest to do this because it's probably not going to go your way if you don't. And that way, because we do like for folks in situations like yours to work most things out before they get here. And things haven't been worked out. And it might be just that you, as David said, you just have a disagreement when it comes down to it, in which case we will deal with that disagreement. But it also sounds like there's opportunities for you to come up with another option. And maybe that's not 50 folks. Maybe that's more than 25 and less than 50. Maybe it's talking to your neighbors about ways to decrease the noise. Whatever those are, I think you need more time. And to do that, you have to say, can we defer this to another meeting? In which case, we will do that, and you will give some more time to work out with your neighbors. And if you can't work it out, well, we'll deal with that when you come back.
Do we not have time to do it today? So it's not something that's feasible.
We can vote today.
I mean talk to them today because they did not show up at the meeting.
I think, this is just my personal opinion, you are so far apart, it's not going to be resolved in a short period of time.
Would they be willing to listen?
I think.
If you give me a little bit of your time, I can tell you right now what it'll take.
Okay.
Triple pane privacy glass on my bedroom windows.
No. We're way outside our rules here. So have a seat, sir, just a second.
Okay.
Members, if you'd like to hear from this gentleman, you can certainly allow them time to come forward, but you need to provide Ms. Perry the equal amount of time.
I think there's just a lot going on, and I think we have given advice to the applicant, and she has the right to have us vote today, but there are 4 people here. You need all 4 of us to support this. And I personally think if you could sit down longer than 10 minutes or half an hour and really have a nice dialogue and try to find some middle ground, not just be over here. and the other people be over here. That's what this is all about.
Okay, that's what I choose to do. I'm going to take your advice and ask that it be deferred to give me an opportunity to speak with my neighbors and maybe even consider less. I could take less than 50 and still survive, but not less than maybe 45 or 40.
We'll talk to them about it, and just also don't talk at them. Just sit down and say, look, I know we've been kind of at odds about this. Just hit the reset button. Okay. Start over. I'm sure these are reasonable discussions that can be had. Your new neighbors sound like nice people. I know Councilman Claiborne very well. So, just hit the reset button and just be reasonable and see what you can come up with.
I sure will.
And you can have this on the 20th or the 4th?
Well, that's the question I was just about to ask. Thanks, Mr. Taylor. As here are our next meetings: November 20th, December 4, and we will be having a December 18th hearing. Those are our next meetings. How long would you like a deferral until?
Once again, that's up to you, and we can put you at the first item on the agenda, so when you come here at 1 o'clock, you'll be up first.
Okay, I think November 20th would be great, because that gives me plenty of time to be able to talk to the neighbor and explain to them that it's not as bad as what they're thinking. They've never lived there.
Yes, but that's for that time. But like I said, the other thing I would strongly say that any conversation that you have with a neighbor or anybody else about this, please involve Councilman Claiborne.
I'd be happy to.
Members, I need a motion and a second.
I move that this be deferred until the 20th of November.
I'll second that.
Motion second deferred to November 21st. All in favor say aye. Aye. Opposed? Moved.
Cases are deferred until November 20th. Members, you did not say, but I'll say for you, this will be the first case on the agenda at our next meeting on the 20th. New notices will not go out. This is the notice of that hearing. So all those parties who wish to be here on the 20th, please be here. We will start at 1 p.m.
Thank you for your time.
Thank you. Mr. Chairman, if you're looking at taking a break, I failed in the opening remarks to place a case on the consent agenda, which I clearly had marked. Mr. Chairman, thank you for bringing it to my attention. I forgot these folks. So before I put them on consent, are there parties present in opposition to case 2014-101, Christian Perot and 9 Marks LLC, owner of the property at 288 Broadmoor Drive? Any parties present or have opposition to case 101? Okay, Mr. Chairman, seeing none, this was a request and a change of non-conforming use from warehouse to light manufacturing. You had received a letter from the council lady, Bennett, recommending approval, and Mr. King, you had also listed to me that this should be placed on consent. And so
we'll need a motion to add that to consent.
Actually, have a motion. We just need a second.
I'll second it.
All in favor say aye.
Aye.
Opposed? So moved.
All right, Mr. Perot, thank you. Your case has been approved. I apologize for having you sit here for over an hour, and you did not need to. So that case has been approved. Mr. Chairman, do we continue on?
Just a brief break. 3 minutes.
Okay, the board stand in recess for approximately 3 minutes. We'll be right back. You'll have 10 minutes. Let me go through my slides first, and I'll turn it over to you. The subject property is located on the north side of Gallatin Pike, just west of the Sumner County line. That's the dark black line which you see there is Sumner County and Hendersonville there. The subject property you see are the parcels involved here in the red. The nature of the request is a sidewalk variance that is being asked to not to install the sidewalks along Gallatin Pike. This is looking at the subject property upon my visit to the site, looking from Gallatin Pike is behind me, facing to the north. Those white tanks you see there are property of the city of Goodlettsville. This is a view along his side of the Gallatin Pike, facing in the upper left corner. This would be the area that the sidewalks would be required to be installed along Gallatin, facing to the west there at Woody Steakhouse, and then bottom right facing toward Hendersonville. And then the properties across the street appears to be a Volkswagen and Mitsubishi dealership along the south side of Gallatin Pike there. Okay, with that, I'll turn it over to you, sir. If you would, please state your name and identify yourself and make your presentation.
Thank you. My name is Adam Sager. I'm with Dale & Associates. We are the engineer on the project. As Mr. Hargis said, the subject property is the second to last parcel on Gallatin Pike. It's on the north side of the road right before you cross over into Hendersonville. It's under construction. It has been approved for an automotive sales. And I'd like to make it clear on the front end, you know, when we first started on this project, we anticipated that there might be sidewalk. Our client isn't opposed to sidewalk. There's no anti-sidewalk going on here. It's just that as we progressed through the design of the project, we realized that sidewalk, one, just didn't make sense, and two, just creates more problems than what it's worth, and quite frankly isn't very feasible in this particular location, and I'll go through those reasons as I outlined on the submittal letter in the hardships. One is the potential hazard or to public welfare. As you look at that road, it's 45-mile-an-hour speed limit. People are coming down through there. It's very heavily trafficked. And when we introduce curb, gutter, sidewalk, the section that Public Works requires of us, it will create an abrupt introduction of curb and gutter, and then and then it'll go back on its way after it leaves the property. And so it kind of diminishes the room for error if you have to pull off on the shoulder, and you don't see it coming, especially at night. As we moved along, I mean, I understand we develop a lot of sites. I understand you've got to start somewhere with the sidewalk and curb and gutter and all of that, and so we get that. But so we moved on, and we actually designed the curb and the gutter and the sidewalk in this location. And very quickly, we realized that this was a problem. The configuration, the unique configuration of this site with the roadside ditches, the adjacent driveways coming onto, or on the north and the south side of us, creates a significant stormwater problem. It's going to concentrate flow off the road. This road is currently designed to have all the sheet flow come off of the side. We are unable to install inlets adequately along where the curb needs to go. There's existing gas mains and utilities in the way that would make it, you can't put inlets there. And so you'd have a collection of concentrated stormwater flow coming off, and then it would have to come around the end and then discharge into, basically you'd have to create a hole, catch it with head walls, just to adequately convey it all. And finally, this location just doesn't really warrant a sidewalk. You look up and down all of Gallatin Pike in this area, there is no sidewalk or curb and gutter. You have to go to the west about 1,600 feet before you see any of it. And there's none on the south side. And then as you go into Hendersonville, there's no sidewalk, curb and gutter going across the bridge into to that side of it. Furthermore, we have met with Public Works, we've met with codes, we've met with stormwater. We have kind of heard the same story from all metro departments, that this really creates more of a problem than its current situation. We have an email from the Stormwater Department that has been sent to me. I have it with me if you would like to see it. It was submitted.
Yes, we would like that.
And it basically says that Stormwater would prefer the option of keeping the open roadside ditch because it does create the hardship.
But does that say not putting sidewalks? There's one thing Stormwater could say, keep the ditch, but that doesn't say, we're not saying you're not
That's a great
building.
question. It has been explained to us by the Public Works Department that if sidewalks are required, that Public Works will force us to put in the full section of curb, gutter, grass strip, and sidewalk. And we asked that question so we could move the sidewalk only off the road, and then we wouldn't have this problem. But we have been informed that that was not an option, that we have to abide by the requirements in place.
Are you an engineer?
Yes, sir.
So are you saying that this is physically impossible to build a sidewalk in this area?
No, I am telling you that it will create more problems than what it currently exists, specifically from a stormwater standpoint. And
how so?
By the introduction of curb and gutter, you will have concentrated flow on the edge of the roadway that would not exist there today. Furthermore, between the back of curb and the sidewalk, you will have ponding of water and difficulty in getting it to drain.
Fortunately or unfortunately, I know a lot about curb and gutter sidewalks because I had a client that basically wanted to put sidewalks in and didn't want curb and gutter. So please tell the rest of our board what the difference between a sidewalk is. I know our architect knows, but a curb and gutter sidewalk.
Well, there is between a curb and gutter sidewalk.
What's the difference between a normal sidewalk and a sidewalk with curb and gutter?
Okay.
Grass strip, that's what I'm asking.
The grass strip, okay.
I'll say, okay. A curb and gutter sidewalk is a sidewalk and then a green space between the road and the sidewalk.
That's right. They need a 4-foot to 8-foot strip.
Yes. And, in the old days, we'd just build a sidewalk like in Hillsborough Village and there'd just be a sidewalk right next to the street. But nowadays, you go to Green Hills and some of these other places, there's like this little stretch of green space, grass, and then there's a sidewalk. And that's curb and gutter. It requires more space, it's more expensive, and a lot of times Metro requires that now as opposed to just an old-fashioned sidewalk. So they said to you that they're requiring only curb and gutter here. You're saying that you can put it, but tell me the problems of if you were to install a curb and gutter sidewalk, what are the problems? You said stormwater, and be very specific about what that would mean.
Yes, sir. We have been instructed that we are not allowed to keep the open roadside ditch, which means we would have to pipe the conveyance of stormwater. You introduced two items that would make it difficult in this situation. The one item of the introduction of curb, it creates a concentration of flow. When it rains, that water today sheet flows off of the road, like when you drive down the interstate and an arterial type road, it all sheet flows off to the side to, as quickly as possible, get all of the runoff off the road and into the roadside ditch. When you introduce the curb and gutter, it collects that water and creates its own little channel until at such time it can get into an inlet, like you see on minor local roads. People aren't traveling as fast on those roads. In this specific case, we are unable to install any inlets to collect that water. And so for the entire length of the property, it will be collecting all of that runoff on the side of the road until at such time it can get to the end of our property, and then it will concentrated flow off into the ditch, which actually creates its own erosion problems, but that's kind of minor considering the items we're talking about here. The second item is that when you pipe this area, it's a shallow ditch. There's really not enough cover. You can't get inlets in there. And without going into too much detail, it's easier over a set of drawings or to see it in the field. But basically, it's going to create a very difficult situation for the surrounding property to adequately drain. You might create some little bird baths just because it's pretty flat. It's hard to drain.
But I'm not saying I agree with this, but doesn't the curb part, the green strip part, actually take some of the water away from the rest that you were talking about?
No, the green strip is elevated 6 inches higher than the road. So basically all of the water runoff I'm talking about from the curb would come from the road. It's what you're driving on. And the green strip is behind the curb, it really does, you're right. I mean, it doesn't contribute that much. In fact, it would probably absorb whatever rainwater it had. And then behind the grass strip, you have the sidewalk. The point is all the one, the road collects the water. And then two, the surrounding areas behind it, it makes it very difficult to drain the water. And finally, one last thing I wanted to add, and I did receive a letter from Councilman Pardue. I have that, and I can pass around that as well. He is.
We already have that.
Okay, great.
Anything else to add?
And Councilman Pardue in his letter says he's expressing his displeasure with the requirement of the sidewalk in this particular location, of course, but this is a Metro Council, Metro law, that there is no existing sidewalk in the area. It's a major highway, and the shoulders and ditches doesn't seem appropriate or practical, and appears to create more problems than help. So that's what he has said.
Yes. And I think that's it. I'll answer any more questions, and I do appreciate all your time and consideration.
Any other questions? Okay, Joe, we'll close the public hearing on this.
We'll close public hearing on case 98.
Discussions.
So to educate our Channel 3 viewers, there's a sidewalk requirement now for most major parts of Metro if you do a big renovation or add addition. So if there's no sidewalks there, it triggers in that you have to build them unless you contribute to the sidewalk bank. And we've had this discussion in the past that basically the applicant gets to choose if they want to contribute to the sidewalk bank, pay money, and not build a sidewalk, and that money goes to build sidewalks in other areas, or come to the BZA and say why they shouldn't and name some hardships. We don't have authority to decide whether someone can pay in the sidewalk bank. It is the applicant. So we are here to decide whether they should build these sidewalks or not, and based on the hardships. And, you know, to me, curb and gutter is a little bit more complicated, and, you know, there are some ditches, and, you know, could he do it? If they spend the money, I'm sure they could. But, you know, there are a lot of hoops to jump through. This is not an easy, I'm just wanting to get out of some sidewalks. There are some issues, but, you know, if they spend the money, could they put sidewalks? There was a case with the Bordeaux YMCA, which was like a steep slope that they asked to be omitted from that requirement, because literally physically, without just putting in a lot of dirt and doing a lot of things, you couldn't build sidewalks there. It just was not feasible. Here, you could probably do it, but it's challenging. So that's where we are, board.
Yeah, absolutely. For those folks on Channel 3, they're still with us. all four of you watching still. We appreciate it. No, that's great. I agree. It's been a long hearing, and this is important. And we talk about it a lot, but we have a clear history of when, especially with council support and significant topography issues and cases like this where it doesn't appear that one change is going to change the entire length of this street. I mean, that was, we think, the spirit of the rule, and we know where it's applicable and where it's not. And this, to me, meets all the criteria of needing a variance. And so I'm happy to move that we approve this variance based on all the criteria for the variance being met.
Okay, we have a motion.
Is that a second?
I'll second that.
And a second. Any other discussion? All in favor of the motion, say aye.
Aye.
Opposed? So passed.
Mr. Chairman, our next case, case 2014-99, Ms. Barbara Gardner. If you'll come forward, please, ma'am. Ms. Gardner is, as you all saw earlier, Councilman Hunt came here in support of you. Ms. Gardner is requesting variance in the street setback in RS5 to construct an 18-foot, if I recall, by 11 carport to the front of the residence.
Good afternoon. Introduce yourself, please.
Yes, my name is Barbara Gardner, and I'm here for a carport, please.
For your Buick. Now, Councilman Hunt really made the case for you very well. And we talked about the Buick being 16 feet long. And so is 17 feet acceptable to you for the size of this carport?
Yes, that's fine. That would be fine.
You're sure?
I thought they said 18, but.
Okay, well, we'll do 18. Is
Okay.
18? Okay. Do you have anything else to add that, Councilman Hunt really made a good?
He did a beautiful job.
Okay. So any other things to add?
No.
Okay. No questions? Any questions from us?
No, she's agreeable. Good prelude into this, all right? Close the public hearing?
Close public hearing on case 99.
All right. Discussion?
No discussion. I make a motion that we approve the carport for 18 feet. And
Some condition you guys have placed on carports before that they're to remain open.
Oh, yes.
So it's not to
The
close it and make a
carport shall
garage
remain
out of it.
open. What that means is you can't enclose it and make it like a garage or something like that.
Sure.
Okay,
Fine.
so we're giving you an 18-foot carport that remains open.
Okay.
Anything? Okay.
Okay, that's motion second.
Second.
Discussion? All in favor, say aye.
Aye.
So moved.
All right, Ms. Gardner, you're approved.
You have your carport, ma'am.
Thank you.
Ms. Gardner, come see us at our office beginning on Monday to pick up your permit, okay? Yes, ma'am. Good to see you. Okay, final case today, case 2014-102, Oman Gibson and Associates, the appellant, Kelly Properties LLC, owner of the property at 1001 Riverside, requesting an item D, which is a change of nonconforming use in the CL and R10 districts to change from one nonconforming use, which was a grocery store, to another nonconforming use. Applicant's proposing to put a dialysis clinic in this, referred to the board under section 1740-650D. The appellant has alleged jurisdiction
Mr.
under
Hargis?
section 1740-180.
I'm sorry, but I am going to have to leave the hearing. So if there is opposition, I want to let the parties know that.
Is there opposition?
There's opposition present.
I don't think I'm going to,
So I
just
think
hate
we
to
should just
start.
put this at the first case of the next meeting then.
And I'm terribly sorry. I'm not going to be able to stay.
And to explain for the folks here, our board requires that 4 members be present to hear any cases. Ms. Chappell unfortunately has to leave. So with that, I only have 3 members here, and this meeting, upon her departure, will be over. What happens is this case will be put very first on our agenda next time, and will be heard before we hear any of the business on the 20th. This case will be heard first.
I apologize terribly.
Did we promise the other people that was first, or?
Ms. Perry.
Well, actually, under our rules, you're going to have to be first on this one.
Okay, well, we'll communicate to the
We'll
other
punt them
folks.
to 2, but. And with the record reflecting and with all due apologies to all parties here, Ms. Chappell's departure, this board's zoning appeals is adjourned.
Really sorry.
Again, this case 102 will be heard first on the 20th of November. All right. Yes.
Is there any way we could get a special hearing? That really creates a significant
Talk with me. Yes, talk with me, members. I need y'all silent on this one. Come see
Joey,
me.
I can't speak for everybody, but it's one of those things that, we've just all got to agree on a time. The chairman of the BZA has the right to call a meeting at any time. I don't know how it works with advertising and such.
We can do that, but I will need to.
But he needs to get at least 4 people that can show up in a time where you can show up and the opposition can show up too.
Let's discuss after this. But this discussion will be for the office since we're on camera. This is our discussion as secretary and we cannot discuss this with the board in front of them. So at this hearing. So with that, Board of Zoning Appeals is adjourned. This meeting's over.